and mining for the state of Utah. This is the May 27th, 2020 virtual meeting of the Utah Board of Oil, Gas, and Mining. We welcome you. We've had a great briefing session this morning. We do have a number of items to discuss today, and so we'll move to our agenda. Court reporter, are you available and can hear us well? I just want to confirm the court reporter is ready to go.
Yes. Good morning. I can hear you great. Thank you.
Thank you. We have changed my microphone in hopes that breaking up won't occur again. So with that, the first agenda item is docket number 2019-014, cause number C/007-0045. In the matter of the request of the Utah Division of Oil, Gas, and Mining regarding the Wellington Dry Coal Cleaning Facility. This matter has been continued to the June 24th, 2020 board meeting. There was a question a little bit about the letter of intent from the surety that the bond funds would be utilized for offsite reclamation. Is there anything that the board needs to know about that decision at this time?
Chairman Gill, this is Haley Souza for the Division of Oil, Gas, and Mining. Can you hear me all right?
Yes, I can hear you and see you. Thank you.
So the surety, after we sent out the notice of hearing for the motion to reconsider, the surety contacted the division and requested that they be allowed to complete the reclamation work. The coal rules are a little different from the oil and gas rules in that they don't allow for the surety to complete the reclamation work after the bond has been forfeited. And the last order of the board took that action. It forfeited the bond. So the division wanted to have some discussions with the surety to understand their intent and understand what actions they were proposing for undertaking reclamation. And that is why the division requested the motion for continuance, so that we could get together with the surety and have those discussions. The division wants to be very clear that right now, pursuant to the board order, the division is not taking any action with conducting any offsite reclamation using those bond funds. That was just a piece of the discussion that the division had with the surety, and we wanted to capture that so that so that the board could be fully apprised of those conversations going forward. But I just wanted to be clear that no actions are being taken on that offsite work with any bond funds.
Thank you. Board members, any questions on this issue before we move to the next agenda item? Thank you, Haley, for that briefing. We'll now move to agenda item number 2, docket number 2020-005, cause number 379-01, in the matter of the High Point Operating Corporation for an investigation and a hearing to determine why Paradox Upstream LLC has not paid proceeds attributable to royalties and other burdens. My understanding, this matter has been continued to the June 24th, 2020 board hearing. Is there anything that we need to be aware on this issue from anyone on the staff? Seeing none, we're on to the agenda item number 3, docket number 2020-09, cause number S02-10035, in the matter of the action by the Utah Division of Oil, Gas, and Mining concerning Highland Mist Mine and Cornerstone Industries, among others. Okay, we'll take a, let me make sure I've got the right matter here for me. Okay, we'll take appearances of council at this time.
Chairman Gill, this is Haley Souza for the Division of Oil, Gas, and Mining. I understand that other council is also present.
Chairman Gill, this is Mitch Mayo of Lear & Lear PLLC. I'm making an appearance in this case on behalf of Mr. Greg Yoder, the current kind of end user in this in this action.
Okay. Are there any other appearances of council at this time? Seeing none, I believe Ms. Souza, we'll go with you. Haley, if you'd start.
Sure, thank you. So just a little background on this case. The division filed this notice of agency action wherein we anticipated that we would request forfeiture of the bond, but Mr. Mayo was retained last week by Mr. Yoder, and he and I have been in contact and have been discussing possible solutions to this situation. So he and I believe that the division and his client can come to a resolution for voluntary forfeiture outside of this notice of agency action. And so my understanding was that Mr. Mayo was going to make a motion for a continuance at this time, which the division supports. And in the interim between now and next month, the division anticipates that it will be able to hammer out the details of that voluntary forfeiture such that we can potentially dismiss this notice of agency action prior to that meeting. So I will let Mr. Mayo go ahead and make that motion, and just know that the division is in support.
Oh, Mr. Mayo.
Yeah, I appreciate that, Haley. That's a pretty accurate and succinct summary of the discussion. I was contacted about 5 or 6 days ago by Mr. Yoder, who acknowledged, kind of the late approach to resolving this on his behalf. But what Haley and I have discussed is essentially what she said. I would like to move for a continuance to the June hearing of this matter. The idea being that the division and Mr. Yoder will continue to work on essentially the details of a plan for how this spoils pile will be removed and reclamation will begin on this Highland Mist Mine area.
Thank you very much, Mr. Mayo. Board members, how we're going to do, we're going to take a roll call vote. But before we do that, is there any discussions or questions for council from any board members on this matter? Seeing none, we'll have a roll call vote. The motion before you is to continue this matter until the June 24th, 2020 board hearing. Let's have a roll call vote.
Mr. Richard Borden, how do you vote, yay or nay?
Yay.
Mr. Michael Brown, how do you vote, yay or nay?
Yay.
Mr. Stephen Church, how do you vote?
Yay.
Ms. Susan Davis, how do you vote? Ms. Davis? Mr. Ruland
Yay,
Gill?
sorry. I voted yay. I was on mute, sorry.
Thank you. Mr. Ruland Gill, Chairman, how do you vote?
Okay.
Mr. Chris Hansen, Vice Chairman, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Yay.
Thank you. Mr. Chairman, I have 7 affirmative votes.
Okay, this matter is continued till the June 24th, 2020 hearing. We are on agenda item number 4, docket number 2020-010, cause number 470-02. In the matter of the request for agency action of Bainbridge Uinta LLC. We'll take appearances of counsel at this time.
Chairman Gail Mitch Mayo of Lear & Lear PLLC on behalf of Bainbridge Uinta LLC.
Okay.
And Haley Soda for the Division of Oil, Gas, and Mining.
Okay. Any others? Okay, Mr. Mayo, would you, introduce your witnesses and swear them in?
Happily, Chairman Gill. With me today for Bainbridge are Russell Griffin. He's a consulting petroleum geologist with Bainbridge. Mr. Jeff Seifert, who is the Director of Reservoir Engineering for Bainbridge. And Mr. Michael Anderson, who is the Senior Landman for Bainbridge.
Mitch, we're getting a lot of double feedback on the phone.
I am too. I did a check on the business call. For some reason, it backfired here. So me.
Okay. Let's have your witnesses sworn at this time. So we have 3 witnesses.
Oh, okay. Will you raise-
please go.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Will you poll each witness to see that their answer was? So, Mr. Griffin, was that I do?
Yes, it was.
Mr. Tucker, is that also yours? I didn't.
Yes.
And then Michael Anderson is.
Yes, sorry, there's a lag between everything, kind of cutting out.
So we're back to you, Mr. Mayo.
Okay, Chairman, I've taken out my headphones. Is that better? Can you hear me?
No, it's not as good as it was before. Let's try that. Is there another option?
Well, let's see if we can do this again. It may be.
Is that still giving the same feedback, or is it improved?
Improved. Much
Okay.
improved.
I'll try and stay in exactly this position then, Chairman. I apologize. Thank you for that. The witnesses are here today. Just so you know, Mr. Anderson and Mr. Seifert have both been allowed under Texas orders. It's my understanding they've been allowed to be back in the office together. So they will be sharing a computer. They're going to try and stay away from each other during that time. So to the extent we need to switch back and forth between Mr. Anderson and Mr. Seifert, just allow for that kind of transfer. I would also like to make clear at the outset, I've got my cell phone on. I don't typically do that in hearings, obviously, but it's in case I need to coordinate with my clients on kind of a sidebar. Please excuse any interruptions in advance. Before we begin, I'd like to just take a quick second and thank IT staff at the division and the division and board staff for holding this hearing today. Mr. Chairman, members of the board, the resumes of the 3 witnesses have been submitted collectively as petitioners exhibits 18 and 20. If separately asked about the contents of their resumes, each of them would confirm them to be true. Mr. Anderson will be testifying as a fact witness today in general land matters. Mr. Griffin and Mr. Cipher will both be testifying as experts in their respective fields in petroleum geology and reservoir engineering, respectively. Mr. Griffin has testified before this board as an expert in geology on numerous occasions. However, the most recent time is probably about a decade ago on behalf of QEP. So to the extent necessary with division stipulation, I will either present their expert testimony or qualify them as experts during their individual testimonies.
Division? Any objections? Proceeding that way?
I'm conferring with my client. Can I just have 1 second?
Yes.
Sure.
Thank you. Thank you for your patience, Mr. Chairman. The division would appreciate some background information on the expert witnesses, given the length of time between since the last one has, in the 10 years since one has been a witness and the other has not. So when the time comes for them to testify, if Mr. Mayo could please provide some background information, that would be helpful for the division.
Sure. I'm happy to do that. That seems totally fair. I will qualify them during their testimonies when they are called, if that's okay.
Yes. Proceed.
Okay. With board's permission, I will be moving for admission of all my exhibits at the end of my case in chief.
That's right.
Okay. Mr. Chairman, members of the board, the request here today, although it seems complicated at times, is actually fairly straightforward. Bainbridge is seeking only two minor adjustments to the current existing spacing orders that are in place on these lands. Those adjustments are a 130-foot extension, if you will, or reduction, depending on how you look at it, in the north and south setbacks that are allowed for wells on these lands, and a deepening of the formations from which these wells can produce, along with the ability to commingle production. Those are the two issues that we're facing here today. The lands at issue today are in the Three Rivers field, which are located in Township 7 South, Range 20 East, and Township 8 South, Range 20 East, both in Uinta County. The orders that Bainbridge seeks to amend are those orders entered in cause number 270-02, 270-04, and 270-06. Bainbridge seeks to continue anything in those orders that it does not seek expressly to amend here in this hearing. As I mentioned, the reduction in north-south boundary line setbacks from 460 feet to 330 feet, and the expansion of the productive formations from which future wells may produce to include production from the upper portions of the Wasatch Formation are the only two changes that Bainbridge is seeking today. If the formation is approved, production of oil, gas, and associated hydrocarbons from wells on these lands will be allowed from the Eocene Middle, the Lower Green River, and the Wasatch Formations. I may call those the subject formations here at this hearing. The relief requested here today is similar to and consistent with relief granted by this board in numerous prior causes for horizontal wells and in cause number 270-08, covering sections of land just north of the lands that are at issue here today. And in cause number 270-03, covering sections of land just south and some north of the lands that are at issue today. The board has jurisdiction over this cause pursuant to Utah Code 40-6-5 and 40-6-6. Notice was sent via certified mail, return receipt requested to all mineral leasehold and production interest owners and to all relevant governmental agencies within the lands at issue, as well as to all similar owners within a half-mile buffer around the lands at issue. Each of these mailings was either sent to the address provided by the governmental agency or to the last known addresses of record in the office of the county recorder. Several of these mailings were returned undeliverable. Some included a notice regarding a new or revised address, and in those cases, we mailed a subsequent copy of the request. It should be noted at the outset, we filed yesterday an exhibit that is non-substantive, but was a scanned collection of the return receipts and mailings that we received back regarding proof of notice. In addition, notice of this hearing was published in the Uinta Basin Standard and Vernal Express on May 5th, 2020, and in the Salt Lake Tribune and Deseret News on May 3rd, 2020. The division did not file a staff memorandum in this cause, and Bainbridge and the division did receive one comment letter from Robert L. Bayless Producer, LLC, which we will briefly address during Mr. Anderson's examination. With that, if there's nothing further, I'd like to begin my examination of Mr. Anderson.
Yeah, during your examination, would you give us a little background on Bainbridge? I believe this is the first time we've had them before us in a long time. So if you wouldn't mind, that would be helpful, I think, to the board to just get a little background information.
Happily. Yeah, I think this actually is the first time that Bainbridge has appeared before the board, if I'm not mistaken. I represented Bainbridge in a public comment in a February hearing that was CH4 Finley hearing. But that was the first appearance that Bainbridge ostensibly made. And I will actually, if you don't mind, turn the time over to my witness. I'll do a little preamble discussion with him, and then I'll have him kind of briefly discuss who Bainbridge is and what where they work and when they came in and all those things.
Thank you. Yes, proceed.
Okay. Michael, are you there and can you hear us?
I am, and I can hear you guys.
Okay. Would you begin by stating your name and business address for the record?
Yes, yes, sir.
Board members can see who we're looking at. Michael, which screen should I look at here? Michael, raise your hand, please. Okay, everybody see Michael? All right, we got you.
Okay, great.
What is your current position with Bainbridge, Michael?
I am a senior landman for Bainbridge Uinta LLC.
Okay, and are you assigned to the Three Rivers project area?
I am.
Okay. Have you testified before the board in Utah before?
I have not.
Okay. Do you exercise a supervisory role over the land records associated with the lands that we're dealing with today?
I do.
Okay. And lastly, can you please provide the corporate and bonding status for Bainbridge?
Yeah, we are a Texas corporation, good standing, having principal place of business in Dallas, Texas, fully and appropriately bonded with all relevant state, federal, and tribal agencies.
Okay. As a reminder, Mr. Anderson's just a fact witness here today, so there's no need to qualify him as an expert. Before we begin with your exhibits, the chairman asked, can you give a quick, kind of 1 minute introduction, who Bainbridge is, how they came to be involved in the Uinta Basin, and anything else that you'd like the board to know about Bainbridge? Yeah,
Bainbridge is, we purchased the Ultra asset October of 2018. Largely focused in the Uinta Basin. We've got the all of the Ultra field staff. So the field staff that we have in Vernal is much largely from the Axia Ultra days, but we are a small operator based out of Dallas. A lot of years of experience on the operations and production side, and really love the Uinta Basin and the asset that we have.
Okay. Chairman Gill, any questions? Feel free to jump in if you'd like to find a little more about Bainbridge.
I'm happy with that. Thank you.
Okay. Thank you. Michael, if we could turn to, let's just start with some exhibits, and I'm going to attempt to share my my screen now and see if I can do this correctly. So bear with me while I make sure I figure it out. I am going to present, let's see. Now let me see if that works. Can you guys see the presentation exhibit, or are you still looking at me?
Still looking at you, Mitch.
Oh, that's unfortunate. Let me see if I can. Okay, how about now?
Perfect.
Okay, great. Let's start off if we can, Michael. I'm going to try and navigate here with exhibits 1 through 4 and exhibit 2.1 here. Do you recognize these exhibits?
I do.
And were they prepared by you or under your direction or supervision?
They were.
Okay. These exhibit 1, briefly help orient the board as to this exhibit and cause where we are.
Yes, board. This exhibit 1 is going to be the Three Rivers location map. On the left-hand side, you will see the state of Utah, with the gray dots being, in essence, oil and gas activity. And if you look into the northeast corner of the state of Utah, you'll see a blue check mark or a blue square, and you'll see the image to your right, which in essence just shows where our field sets in relation to the state.
Okay. Exhibit 2, please help the board understand what this exhibit demonstrates.
Yeah, exhibit 2 is a slide showing the relevant space lands where increased drilling density has been previously ordered in other matters. What you see on the larger image is you'll see five spacings that show 20-acre well density, 2 wells per 40. And then in the lighter pink to the very far left of the larger image, you will see a 2 wells per 20 acre spacing that was previously heard and ordered by the board for 2 wells per 20. And then in the top right-hand corner of the slide, you will see just where our position sets in relation to Roosevelt, Vernal, Ouray, and Mighton.
Okay. And so this, just to clarify for the board, Bainbridge is not seeking to increase well density. The well density in place under this yellow area is 2 wells per 40, and that's the density that Bainbridge is seeking to just maintain at this hearing. Is that correct?
That is correct.
Okay. And this yellow 27002 covers lots of lands. Not all of those lands are subject to this hearing today. Is that also correct?
That is correct.
Okay. Turning to exhibit 3, I'm going to skip past that one for a minute. Would you please describe this exhibit for the board as well?
Yeah, what you'll see here, board, is the development density. You'll see 4 things here. You'll see mainly starting with the area of request. It'll be a bold red outline that shows where our leases are located. And then next you will see a reddish colored, fully developed 2 wells per 40 with the wells that are producing on those lands. And then you will see some green lands that show future development where we intend to have these this request be utilized on those lands to for future development. And then lastly, you will see areas with bold red and an X through them. Those are acres excluded from this request that are not owned or under control by Bainbridge.
Okay. And these white boxes here, are those included in the request?
They are.
Okay.
They were intended to be green, as we do not have development on those lands.
Okay. So just to sum up, I guess what you said is the pink is area, these are included in the request, but they are fully developed, meaning they already have 2 wells per 40 acres.
That is correct.
And the green, also included in this request, is where Bainbridge is seeking to essentially continue to develop because they only have 1 or no wells per 40 acres.
That is correct.
Okay. Turning to Exhibit 4, tell the board what this exhibit demonstrates as well, if you would.
This is just another look at the previous slide, but in a different variation. What you'll see here is again, the area of request in bolded red, that where our Bainbridge leases are located. It may be a little bit difficult to see. However, there's going to be a red dashed line that will be on the north and south boundaries of these lands that represent 330 north-south setbacks. And then you will see a blue dashed line on the east and west boundaries that represent 460 setbacks.
Okay. And those apply to these internal areas that were accepted from the request as well, the 330 north-south and the 460 east-west to those accepted lands. Is that correct?
That is correct.
Okay. Now let me see if I can zoom back out. And one thing to clarify, there was some confusion in the request as drafted and the division pointed out. I just wanted to make sure we clarified on the record. There are actually 2 different setbacks that Bainbridge is seeking. One is an amendment, as I said, of the 330-foot or the 460-foot north-south setbacks that are currently in place, seeking to reduce that to 330 feet. The other, Bainbridge is not seeking to amend, and that is the current spacing setbacks that are in place, which, as we have clarified with the division over the past weeks, represents essentially a 100-foot section or lease line setback if ownership is the same. Is that your understanding of the request here today?
That is correct.
Okay. So in essence, the spacing order as it's been applied and entered on these lands continues. The only modification as far as setbacks is the reduction of the north-south setbacks.
That is correct.
Okay. I'm going to turn you briefly to Exhibit 2.1 that we skipped over. This exhibit was filed just last week. Why did you prepare and file this exhibit?
This exhibit was created and presented to the board at the division's request.
Okay. And the division was looking simply to kind of figure out how to, in practical terms, how they should apply this order if granted. Is that right?
That is correct.
Okay. What does this exhibit demonstrate?
So this exhibit shows offset spacing orders. What you see here, board, in brighter green are the 3 orders that currently represent 460 east-west and 460 north-south setbacks. And then in darker green, you will see what we were requesting at this issue at 470-02, which represents an additional 130 feet to be included on those, the ones in lighter green, to just be added to our spacing, which is in essence 130 feet addition to the current setbacks, making them 330 north-south and 460 east-west. The green also represents an order that was put forth by the board in cause 270-10 for horizontal wells, where they approved 330 north-south setbacks and 460 east-west.
Okay, so to clarify, this demonstrates the spacing in place is demonstrated by the light green. The dark green represents the spacing that you're seeking to extend in this, the reduction of setbacks on the north and south. Is that your testimony?
Yes, sir.
And the board has yet to approve, at least from your presentation here today, 330-foot north-south and 460-foot east-west setbacks for vertical drilling program, but it has done so in a nearby horizontal drilling program under cause 270-10.
That is correct.
Okay. As far as the 100-foot setbacks that we discussed, as far as the confusion between Bainbridge and the division on the current existing spacing orders that Bainbridge is not seeking to amend, is it fair to say that this map, when it comes to application of those setbacks, would essentially be a green box that is 100 feet from every boundary here?
That is correct, if ownership's the same.
Okay, and that only applies if this section right next door is owned by the same people as this section in the same percentages, then a well could be placed 100 feet from the section line.
That is correct.
Okay, thank you for that. Now I'm gonna lastly turn your attention to supplemental exhibit 21, which we filed yesterday. Do you recognize this exhibit?
Yes, I do.
And was this prepared by my office under your direction or supervision?
That is correct.
Okay. And this, what does this demonstrate?
This demonstrates that certified mailings were issued to all production interest owners within our leases, mineral owners, royalty owners, and offset operators within a half-mile radius of the lands being stated in this request.
Okay. And how did you determine which owners that you should mail notice of this request to?
I first pulled our internal records for whom we pay revenue to on all leases within our position, and then did a county search through UNA County Land Records and pulled any offset operator within a half-mile radius, owner within a half-mile radius of our position all around.
Okay. Did you, Bainbridge, did you receive any responses from anyone who received this notice?
We did. We received a comment letter from Robert L. Bayless, Producer LLC.
Okay. And what did they, Bayless, as I'll call them, what did Bayless state in that comment letter?
They expressed concern for the reduced north-south setbacks as it might negatively impact their ownership of an interest in the Aurora Federal 1526-7-20 well located in section 26, 7 south, 20 east.
Okay. And do you know where the Aurora Federal well is located?
Yes, it is approximately located 660 feet from the south line, 2,000 feet from the east line in section 26, 7 south, 20 east.
Okay. So it's somewhere, to the extent we can generalize, somewhere in this area here. Is that right?
It'll be over to your right, that well right there.
Okay, perfect. And Bainbridge is requesting, as we've clarified, in this situation, ownership on this side of the line and this side of the line are different. And so Bainbridge's request today would allow for a 330-foot setback from this north line of section 35. Is that correct?
That is correct.
Okay, so if the board granted the request as presented today, the closest that Bainbridge could drill a future well is almost 1,000 feet away from the Aurora Federal well. Is that right?
That is correct.
Do you believe that 1,000 feet is too close for wells to be drilled and located to one another?
I do not believe, as default spacing is conservative by nature and allows wells to be located 920 feet away from another one.
So if the board grants this request here today, the closest Bainbridge well would be located and locatable farther away than default spacing would allow.
That is correct.
Okay. Do you know who operates the Aurora Federal well?
Yes, it is Finley Resources, Inc.
Okay. And did Finley file a comment letter in this cause objecting on the same grounds as Bayless?
They did not.
Okay. Did Finley file any comment letter in this cause?
They did not.
Okay. With that, I am done. I have one final question, Mr. Anderson. In consideration of Exhibits 1 through 4, Exhibit 2.1, and Supplemental Exhibit 21, do you believe that the request under consideration today is the best plan to protect correlative rights, prevent waste, and maximize resource recovery?
I do.
Okay. With that, I'm done with my examination of Mr. Anderson.
We'll have cross-examination from the division. Proceed.
Yes, the division does have one clarification question. I'm going to request that Mr. Dustin Doucette ask that question. Dustin, are you there?
I'm here.
Proceed.
So if you go to exhibit 2.1, that latest one, I just wanted to clarify, I think the testimony was to this section line. These setbacks are being requested from the unit, the drilling unit boundaries, is that correct? The essentially 40-acre drilling unit boundaries that have been established for 2 wells per unit?
That is, oh, sorry.
Go ahead, Mitch.
That is correct.
Okay, so that is a representation of a drilling unit, not necessarily a section.
It is a representation of a section. It is also applicable to a quarter drilling unit as well.
Okay, so just to confirm, you were asking for the 460 within the drilling unit boundary to be reduced to 330 feet where there is not contiguous ownership or lease is the same between those offsetting units, correct?
That is correct. Where ownership is not the same, it is reduced to 330 feet. That's Bainbridge's request. Where ownership is the same, it is maintained at the current spacing, which is 100 feet.
Correct. Okay, thank you.
Okay.
Hey, board members, any questions from the board members of this witness?
Are we talking strictly vertical wells that we are spacing here, or is this for horizontal wells?
Strictly vertical wells, Ms. Davis.
Okay, that was Susan Davis. I forgot to mention one of the requests would be you identify who's asking the question. So Ms. Davis, you have the mic until you say I'm done.
I'm done.
Okay. Anyone else have any questions of this witness? Seeing none, thank you. Mr. Mayo, call your next witness.
Sure. I'd like to call Mr. Russell Griffin as my next witness.
Proceed.
Russell, are you there and can you hear us?
Yes, I can.
Okay. And can everyone hear Mr. Griffin just fine?
Yes.
Okay. Mr. Griffin, will you please state your full name and your business address for the record?
Russell Allen Griffin. My address is 110 West, 500 North, Roosevelt, Utah.
Okay. And please tell the board your job title and your job responsibilities generally and as they relate to the lands that we're dealing with here today in this request.
I'm a consulting petroleum geologist with XRG Consulting. I've been primarily responsible for consulting with Bainbridge on exploration and project development in the Uinta Basin, and specifically with the lands located here in the Three Rivers field that we're discussing today.
Okay. At Division's request, I know that you have testified before this board as an expert in geology numerous times before, but because it has been about a decade, if you wouldn't mind briefly discussing your resume with us. I've got it here pulled up as an exhibit, but tell us about your education. Where did you go to school? What did you study, etc.?
So I attended Utah State University. I have a bachelor's degree in geology. After graduation, I went to work for Chevron when they still had a presence here in Utah in the Uinta Basin. I worked for Chevron for 6 years. When they sold their assets, I, rather than deciding to follow Chevron, I stayed in the Uinta Basin and I worked for Shenandoah Energy, Questar, QEP, and Wexpro, specifically here in the Uinta Basin, for a cumulative about 25 years of experience here in the basin. I've also worked outside of the basin as I moved up through the ranks in management. So I've worked at the corporate level through the Bakken Formation, the Permian, Greater Green River, Paradox, Piceance, and the other basins here in the area. So as Mitch mentioned, I presented previously between 2000 and 2010 to the board, and those were for causes related to Questar for modification of the spacing rules in Wash-Wansit's Valley area, which are immediately east of this field. And then when I moved into middle management, I mentored and coached other geologists that presented to the board. So presentations that were made to Board Oil, Gas, and Mining after 2010 on behalf of QEP were my staff and people that worked with me and for me in that situation.
Okay. And how long have you been working with Bainbridge on this asset?
I've been working with Bainbridge since September of 2018.
Okay. And you, as you said, have experience and are involved with the lands at issue today?
I am.
Okay.
So additionally, having worked 25 years in the basin, I'm also
I'm sorry. I'm so sorry. Can I have you speak right into your mic? You're cutting out a bit. Thank you.
So in addition to 25 years of experience, I'm also a professional geologist licensed to practice in the state of Utah.
Okay. Thank you, Mr. Griffin. Haley, excuse me, Miss Sosa, Division, any voir dire necessary on your end?
No, the division is okay with Mr. Griffin serving as testifying as an expert.
Okay. Board members, any objections to this witness testifying as an expert in geology? No.
Mr. Chair, I don't have any objection, but I would ask Mr. Mayo if he could blow up his exhibits just a little bit. I don't know how it is for others, but from where I'm sitting, that's much better. Thank you, Mitch.
You're welcome. I will try and do it on a case-by-case basis as I'm going. Please just butt in and tell me if I'm not showing you what you want to see.
I'm done, Mr. Chair. Thank you.
Without a vote, without seeing anyone else raising their hand, Ms. Cypher is accepted as an expert in geology for the purposes of this hearing.
Okay. Just to clarify, Chairman Gill, I think that was misspeaking. This is Mr. Griffin. Mr. Cypher will be testifying later.
Mr. Griffin, I apologize.
Okay. Mr. Griffin, now that we've got that out of the way, I'm going to show you exhibits 5 through 15. And Mr. Brown, I apologize. I'm going to do these on kind of a smaller view so that we can see them all. Mr. Griffin, do you recognize these exhibits?
I do.
And were these prepared by you?
Yes, they were.
Okay. Start with exhibit 5, and I will zoom in now. Before we get into these exhibits in detail, though, can you please tell the board what these 10 or 11, what I'll call geology exhibits collectively show?
You bet. So before we dig into this, the details here, I'd like to give just a brief executive summary of what we're going to see. So 2 main points that we're going to make. We're going to look at the regional stress, how that applies to the shape and orientation of the drainage ellipses. And we're going to look at some exhibits on rock quality. And those are we're going to look at the regional basis and then into the local scale. And so
you're breaking up, sir, Mr. Griffin. Can we get you a little closer to the mic?
How about if I put my headphones on? Does that help?
We'll let the court reporter, but just we're not in a big rush. Just make sure that you consider the court reporter in your speed of testimony.
With my headphones on, does that help the call?
Let's try it.
Okay. So just to recap, the 2 things I want to talk about are the regional stress, how that applies to our specific docket and cause, and I also want to talk about rock quality. We'll tie that into the Green River Formation and the Upper Wasatch Formation, and we will look at an ideal spacing based on the inputs that we see in the geologic data.
Okay. Turning to Exhibit 5, this has been zoomed in. Do you please describe this exhibit and tell the board what this demonstrates?
This is a contour map on the top of the Uteland base marker for the Uinta Basin. And it shows the location of the Three Rivers field in reference to other well-known fields in the field. In the basin. So we have the Greater Monument Butte just to the west of us, Wanted Valley Red Wash just to the east of us. So in between the 2 and a little bit deeper from a structural standpoint.
Okay. And Exhibit 6, let me see if I can get there with the... Exhibit 6, can you please tell the board what this is and why this was prepared?
In a previous hearing, I believe it was the February hearing, one of the members of the board requested a regional stress map, and so it tied in perfectly with the work I was doing. So I went through all 6 years of recent presentations, hearings before the Board of Oil, Gas, and Mining, and I accumulated every slide that referred to the regional stress orientation. So this exhibit is color coded. If I look at a docket and cause an exhibit number, the outline on the call out corresponds with the color of the box for the area that was described in that hearing. So all of the data, last 6 years that the board has seen in one location.
Okay. And Exhibit 7 looks to me similar, but a little less cloudy. Tell the board what this is, if you would.
You bet. For clarity, we removed all the reference boxes, and this is data only. And we can clearly see the orientation of stress and all of the data points that went into mapping that stress orientation. Additionally, in the left, there's a locator map. This is from a paper recently published by the Stanford Department of Geology for orientation for the entire North American continent. I have a red call out, which is the area of interest for the Uinta Basin. And you can see that the data from that report correlates very nicely with what the board has seen in previous hearings.
Okay. And
can I interrupt? I'm so sorry. He's still cutting out a little bit. There's some words cutting out. I don't know if you can get closer to the mic. Sorry.
Let's continue to try that. Michelle, thank you. Please interrupt anytime you cannot hear. We want the record to be complete.
Am I talking too fast?
With you cutting out, you could slow down, but it's just the cutting out part.
Okay.
Mr. Griffin is testifying from his home up in Roosevelt. Is that right?
That's correct.
So it may just be a connectivity issue, but yeah, please interrupt and let us know when we're not being clear.
Hello,
Mr.
this is the tech team, and I just want to interject. If you were to turn off your video camera, like you would mute yourself, to turn off your video feed, it would focus on the audio and we'd be able to hear you. Let's try that. Thank you.
Okay. Thank you.
Okay, Mr. Griffin, where is the Three Rivers field indicated on this stress data compilation map?
So looking at this map, there amongst the data points, there are a yellow and blue rose diagram plots there. Three Rivers Field is located immediately to the south and adjacent to those two data points. Those data points are from FMI, or fracture formation multi-image data.
Okay. And the division has heard a lot, the board, excuse me, has heard a lot in the recent past of fracture azimuth. Is that similar to what we're looking at here?
Yes, it is.
Okay. So these lines represent a visual depiction of what an average fracture azimuth may be under these lands.
That is correct.
Okay. My apologies there. Let's see. Exhibit 8. Please tell the board what this exhibit is. And first of all, clarify, if you would, whether this is Bainbridge data or publicly available data.
This is publicly available microseismic data from prior hearings to the Division of Oil, Gas, or the Board of Oil, Gas, and Mining. The microseismic data is notoriously difficult to come by public record. But here are two good examples, one to the east of the Three Rivers Field, the other to the west of the Three Rivers Field. And when I worked for Questar QEP, I also was involved in a number of other microseismic projects, so I'm very familiar with the overall interpretation and data as it relates here in the Uinta Basin.
Okay, so on the left is a 2020 exhibit showing microseismic data, and that is just to the west of the Three Rivers Field. And on the right is some 2019 microseismic data that is just essentially to the east of the Three Rivers Field. Is that right?
That's correct. The microseismic data is actually prior to 2019, but it was presented to the board in 2019.
Okay. Thank you for that clarification. So these aren't Bainbridge data points. This is publicly available data nearby that you're using simply to help illustrate your position today.
That is correct.
Okay. I'm going to turn you to Exhibit 9.
Let's spend a little bit more time on that one, if we might.
Sure.
So on these two exhibits, the point of the slide is to show the orientation of the stress in the vicinity of Three Rivers Field and the aspect ratio, or the ratio between the long axis and short axis of fractures that occurred during the stimulation event. If we look at the slide, or the upper left, focus only on the green data points. The green data points are from a single stage during a frac that was pumped in a horizontal well. And you can see that those dots, the microseismic events, are almost exclusively encircled by the outer ellipse on that. And that ellipse covers a roughly a 20-acre area. That being said, most of the drainage comes from closer to the well, and so that the inner ellipse represents where most of your reserves will be coming from. So outer ellipse, 20 acres, inner ellipse is predominantly the area of drainage.
Okay.
Green River Formation. The exhibit in the upper right is another microseismic event. This was in the Mesa Verde Formation, so not a perfect analog, but it has a very similar aspect ratio and a very similar azimuth to other microseismic events we have done in the area. Same explanation. Outer circle is 20 acres. Inner circle is where most of the drainage is taking place.
Okay, so based on these two, these support, I guess, the existing spacing, which is a density of 2 wells per 40, or effectively a well drains a 20-acre ellipse. Is that correct?
That is correct. But the one point that we want to make is that in a area with no stress, if it was 0 stress, east, west, north, south, we would have perfectly circular or radial drainage. Because of the stress radius, that drainage gets squished down and oriented in a alignment with the regional stress.
Okay, and I guess that helps support the default spacing, which is what I'll call a radial setback from a vertical well of 460 feet in all directions. The idea being default spacing is generally done when little information is known, and so as more information is learned, like this, it appears that 460-foot setbacks on the north or south may and are in fact creating some waste on the north and south. Is that the position?
That is correct.
Okay. Exhibit 9, if you, is there anything else you'd like to say about this exhibit, Mr. Griffin?
No, that's all.
Okay. Exhibit 9, briefly, if you will, help the board understand what this is. Exhibits 9 through 9 and 10, excuse me, are kind of mini geology lessons, if I'm not mistaken.
That's correct. We're setting a regional context for rock quality as it relates to the ancient Lake Uinta. And this is important because it helps us understand where Three Rivers Field sits in relationship to other fields that the board may have seen, and how appropriate drainage spacing might be different in different areas. So to start out, the top 2 slides are an image of ancient Lake Uinta, which was present in northeastern Utah approximately 50 million years ago. I'd like to use the modern Lake Bonneville as a analog for some of how Lake Uinta behaved from a geologic standpoint. So Lake Bonneville is in a closed basin, no exits to the ocean. So as the climate gets wetter, the lake will get larger. As the climate gets drier, the lake gets smaller. And so we have this constantly adjusting size of the lake for Lake Bonneville, and is similarly for ancient Lake Uinta from the Eocene. The reason this is important is if you look at the rock quality as a function of where the beach sets, look at the slide on the bottom. This is, back one, Mitch, sorry. Bottom slide.
Can I interrupt you just a minute? Could you get a little closer to the mic? You're breaking up just a little bit. This is an important slide that we'd like to make sure we fully understand.
You bet. Apologies for the connectivity problems. As close to the router as I could, but apparently not close enough. So the bottom of this slide shows a shore face. If you look at the left-hand side where it says A, this is where you're in the deepest part of the lake. And in the deepest part of the lake, if you drain a reservoir, you're going to see black, stinky mud out there in the middle of the lake. That's low quality rock. As you come up the shore face, out of the water, and get closer and closer to the beach, the wave energy increases, and that wave energy creates larger and larger particles, or sorts out larger particles. And those larger sand grains create more porosity, more permeability. So The yellow band, where Mitch is pointing right now, that's right at the beach where the water's splashing up on your ankles. That is the best reservoir that you could probably have in the Uinta Basin. As you go down, the water gets deeper, up to your knees, up to your waist, over your head. The water, of course, is deeper, but the quality and the size and sorting of the rocks gets, or the sand grains get smaller and smaller and smaller, which corresponds to lower permeability, lower porosity, and smaller drainage areas. Additionally, if you look all the way to the right, up into the purple area, you can see there's a channel fill. That would be where the Wasatch Formation, the rivers that were flowing into Lake Uinta. So I have the full complement. And if you look at the map in the upper right, the little star shows the location of the Three Rivers field. When Lake Uinta was at a low stand, we were right up next to the beach. As the water got deeper and deeper, the beach moved away from Lake Uinta, and we had progressively lower quality rock deposited in Three Rivers Field. So looking again at the shore face profile on the bottom, I have a little arrow that shows the location of Three Rivers Field in orange. So it's lower shore face. Occasionally, we'll get like a little stripe of good rock from a nearby beach. Occasionally, we get really low quality rock coming in these blue and blue-green stripes. But on average, Three Rivers is like right in the middle. Okay. And that's all.
Okay. And Exhibit 10 dovetails with this. Can you please explain this exhibit to the board really quickly?
This slide shows the location of Three Rivers Field, again, right in the middle, and Wansit's Valley Redwash Field, which are really good rock. I mean, these wells in Wansit's Valley Redwash, some of them have made 1 million barrels of oil from vertical, conventionally completed reservoirs. If you go to the west, down that section, till you're out in Central Basin, that's where we are seeing where we need to do 20-acre, 10-acre spacing in order to access all the reserves. And that is in the lower quality rock at the bottom of the lake, as opposed to the good quality rock up on the beach. And again, Three Rivers is just right there in the middle. The lake changed a lot, and that's why we get the little zigzag in each one of those rock quality in the diagram.
Okay. Let's turn to Exhibit 11. Please explain this board to the exhibit, this exhibit to the board.
You bet. So we're shifting gears a little bit here. Previously, we're talking about just the Green River Formation related to Lake Uinta. Now we're looking at how the Wasatch Formation relates to the Green River Formation. So if we have a small lake with a river flowing into it, as the lake gets bigger, the lake deposits will flood over and cap the Wasatch Formation. And then the lake would get smaller and the Wasatch would move in towards the lake. The lake gets bigger, Wasatch moves back, or Green River moves back over the Wasatch. And so we have this interfingering relationship where the lower Green River and the upper Wasatch aren't a perfect knife edge transition from one environment to the other, but it's related to the variability in the Eocene climate. This exhibit in the upper right is actually from an outcrop on the Utah-Colorado border. So this is a very high detailed, high resolution map of how the Green River and Wasatch relate to each other. When we're out in the middle of the basin and we're drilling, one well per 40, we have a small hole, 7 7/8 inch, and we see that little bit of information next to the well bore. It's harder to see this interfingering relationship. Historically, geologists have relied on the first red beds to be the Wasatch. But because of this interfingering, there are multiple Green River slivers that sneak into the upper Wasatch. And this is important for two reasons. One is it gives us an opportunity for oil to migrate up out of the Green River. And the second is that as it migrates up out of the Green River, it can be trapped in the channels, the river channels, which are shown in the dark red. And so you can have oil saturated channels in the upper Wasatch as they come in proximity or in contact with the Green River Formation. Hence the need to commingle the upper Wasatch and the lower Green River from a production standpoint.
Okay. Because separating the two out would probably be administratively difficult, to say the least.
That's correct.
Okay. And why, briefly, did you not include the lower Wasatch in this request? Why does it stop at the upper Wasatch? Is it because of this interfingering that happens in the upper Wasatch alone, or are there additional reasons?
There are additional reasons. As we get deeper into the Wasatch, we lose the opportunity for oil charge into these interfingered sands, and lower Wasatch is predominantly gas charged. So if at some point in the future, the price of gas becomes commercial, we would probably come back and commingle the lower Wasatch and the Mesa Verde into one producing interval.
Okay, so the Green River and Upper Wasatch are going to be predominantly oil production focused from an economic standpoint. Lower Wasatch and Mesa Verde would be a gas production predominantly.
That is correct.
Okay. Let's go to Exhibit 12. This is one that, again, the board has seen several times before, but briefly hit on what is relevant about this for this hearing.
This is our type well that shows the interval that we're requesting to be commingled. So we're going from the Mahogany Bench in the middle Green River Formation down through the upper portion of the Wasatch Formation, approximately the upper 1,000 feet of the Wasatch. Just to walk through the elements of the exhibit, this is from the Three Rivers 34, 31, 720 well, which was a type well in previous hearings. If you look at the first column, where we have the green and with the yellow underneath the curve, that's the gamma ray. So generally, if the farther that approaches to the left, the better quality the rock, the farther it goes to the right is lower quality, higher shale content. In that same track, there are a series of purple tick marks up and down. Those are perforations in this well where the well has been tested and perforated previously. The track with the green line, that is the resistivity curve. And in general, high resistivity is correlative to oil, and low resistivity is correlative to water. Now, the upper part of the well, that's the Mahogany Bench oil shale, which a lot of that, and going above the Mahogany Bench, that's oil in place, but it's inaccessible because of temperature, and it's bonded into the formation.
It's too thick to get to flow. Is that right?
Yeah, that's a good explanation.
Okay. And just to clarify for the board today, the current spacing in place, the formation that Bainbridge or any operator drilling a well on the current spacing is allowed to produce from is the Mahogany Bench down to the start of the Wasatch Formation about here. Is that correct?
That is correct.
So Bainbridge is seeking, in addition to the 130-foot additional setback reduction north-south, the other of the two modifications Bainbridge is seeking is an inclusion of this additional, roughly, I think you said 1,000 feet, upper 1,000 feet of the Wasatch into the productive interval.
That is correct.
Okay. Exhibit Exhibit 13.
So this exhibit is
Mitch and
Yeah.
back to the previous,
Sure.
please. This fascinating geology lesson. Could you zoom in on the type log?
How's that, Chairman?
Yeah, Mr. Griffin, for the board members who are unfamiliar with these type logs, could you point out like what would be for a geologist a real good zone, or what is being shown on this log that you would interpret would be a real good place, probably the best place on here for perforations?
You bet. In general, so there's the gamma ray track on the left.
And that's the green and brown one?
That's correct. And on the right is the resistivity curve. So when the gamma ray goes as far possible to the left, and when the resistivity goes as far possible to the right, that's an indication of oil in place. Now, there are other logs, porosity logs, core, that we integrate into this data, which I'll show on the petrophysical slide later. But the interval in the lower Castle Peak, Butte Butte, that would be, from a petrophysical standpoint, the most attractive interval in this well. That being said, some of these thin slices can have pretty good properties as well and produce a very nice addition to any producing oil well.
So it's not conclusive, but it does give you the beginning point of making some decisions and indicating where oil might be.
That is correct.
Board members, are you clear on that? Does anyone have any questions on just kind of why that is all important in terms of giving a geologist an indication of what might be down there?
This is Susan. I have a question.
Go ahead.
We have seen a lot of these type logs, and we have seen a lot of horizontal drilling. Why are we trying to do vertical drilling here?
The vertical drilling in this area, there's actually really 2 or 3 reasons why vertical drilling makes sense in this area. One is that as we come up out of the basin, there's lower and lower pressures. So in the central basin, we have overpressure cell, they call it, and those horizontal wells produce more effectively in the central basin because of the overpressure.
And Mr. Griffin, let me interrupt. What you're saying is the central basin, meaning the bottom of the lake, is that?
That's correct.
And so as you come out of that towards where the Three Rivers Field is located, go on.
Yeah, we're losing the overpressure that helps squeeze the oil out into the wellbores. However, we also have slightly better rock, and that slightly better rock allows us to more effectively drain from a vertical well. Third reason would be from a risk management standpoint. Horizontal wells are expensive. And some cases 5, 6, 7, 8 times more expensive than a one-off vertical well. So if you're a small operator in an area where horizontal production hasn't been proved, the most risk tolerant, or the less risky way to approach that is with the known quantity of vertical drilling. And again, from the rock quality and the pressure, we think we're drilling it quite effectively with vertical wells.
We are looking at going closer to the drilling unit boundaries. How many wells are we talking about? And how far apart are we talking?
It'll be 2 wells per 40-acre spacing unit, and overall, I mean, that's going to be, well, that is included in Jeff Seifer's portion of the hearing, how many incremental wells. But if you look along the boundary, I'm just looking at the north boundary, there's room for 1, 2, 3, 4, 5, 6, 7 additional wells on that northern boundary. So from an east-west perspective, we're still, 920 to 1,300 feet apart between the individual wells on an east-west basis. But from a north-south basis, we're bringing the wells in just a little bit closer. So it'd be kind of a de facto lay down 20 in a sense.
Thank you, Mr. Griffin. I'm done.
Thank you.
You, Mr. Mayo, with your witness. And thank you for letting us interrupt.
Oh, absolutely. It's a much better way to go about it, to do it as it comes up. So please feel free to do so. One clarification in response to Ms. Davis's question. Again, it might be confusing on my end, and so I'd like to just clarify. There are no additional wells being sought today. So whatever number of wells could have been drilled under the spacing that existed before Bainbridge showed up today, that is the same number of wells that will be allowed if the board grants this request. The only difference will be, essentially if they can scoot them a little closer to those section or quarter section lease line boundaries.
Thank you, Mr. Mayo. That's helpful. This is Susan Davis, and I'm done again.
Thank you. Mr. Griffin, Exhibit 13, Three Rivers cross section. This ties into what we've just discussed. Please help the board understand, again, knowing that 20-acre spacing is already in place, but as kind of further justification.
So this exhibit shows 6 vertical wells drilled on approximately 20 acres north to south spacing. So they're 660 feet and change apart from each other.
Okay, and Mr. Griffin, let me interrupt you just so I can orient the board. These wells are identified as apologize for that, A to A prime, and those correlate to this little outcropping from A to A prime.
Yeah, not an outcrop, but yeah, that cross section.
I just mean outcropping visually from the way we're looking at it. It kind of juts out from our spacing here, but I apologize.
You bet.
Okay.
So if you look at these wells, the 6 wells were drilled, 3 on the left were drilled into the upper Wasatch. The 3 on the left didn't quite make it into the Wasatch, except on the far right that we did. If you look on a well-to-well basis, on 20-acre spacing, we are seeing unique sands, unique Wasatch sands appear. So if we had only drilled on 40-acre spacing, the first well and the third well in this section are 4 apart, 1320. By drilling the in-between well, the 20-acre default well, you can see that there are new unique sands that would not have been encountered on default spacing. Only by down spacing are we able to find those new unique sands and increase our recovery of the reserves in place.
And this goes to Chairman Gill's question just a moment ago about essentially how you look at these type wells to identify those additional sands. This is one of those spikes that you would have noticed on the type well and perforated as part of increasing production in this 20-acre well. Is that right?
That's correct. In fact, I got pretty excited when I saw that sand.
Okay. And this, again, is not justifying an increase in density. We have 20-acre well spacing currently. This is just kind of illustrative as to why 20-acre well spacing is in place and is justified in this area.
That's correct.
Okay. And Exhibit 14. This one makes little to no sense. And Mr. Brown, I will try and highlight or zoom in on anything that you would like to see, but whoa, not like that. But please walk the board through this and help us understand what you understand from this exhibit.
So in the most simplistic terms, we talked about gamma ray and resistivity being key identifiers for zones that we would want to perforate. But in actuality, we do a full petrophysical profile We look at gamma ray, we look at the porosity, we look at the lithology, core data, and integrate that all through using generally a third-party petrophysicist. And we're always improving on that model to get the best oil in place calculation that we can. So this is our latest petrophysical analysis. This is the detailed version of the type log, if you will. And using this data, we're looking at about an average of 7% porosity and about a 30% water saturation. So the other 70% inside the pore spaces is oil and a little bit of gas in there. So that's what we're looking to calculate. And with that number, we're coming up just shy of 100,000 barrels per acre. Now, we can't recover all of those 100,000 barrels. If we could get 100% recovery, we'd be very happy with that. But in the Uinta Basin, generally we look at 4, 5, 6% recovery of the oil in place. And using that number with the sensitivities that we run against place and recovery and the EUR, or the ultimate recovery of the wells, is how we calculate the drainage radius.
Okay. And finally, last exhibit for you, if I can, is exhibit 15, and then I will let you rest. This is an illustrative example only of kind of the conceptual drainage patterns. Can you please discuss this exhibit?
You bet. So to tie together the prior exhibits, the Uinta Basin has an isometric anisotropic stress regime. And so the rocks are being kind of twisted a little bit, which creates an ellipse rather than a circle in the drainage. And with that ellipse happens, if I had a perfect circle, then 460 north offset, 460 east-west offset would make perfect sense. But as I squish that down with the 460 offset, I'm progressively leaving more and more oil behind along the lease boundary. So by adjusting our spacing and our setbacks, we're able to maximize recovery and put as many wells into this pattern. And it isn't necessarily about the number of wells, as Mr. Mayo said. It's about how we arrange those wells to maximize the space covered by each ellipse.
Okay. And so I think that's good. Is there, if I can sum up briefly, Mr. Griffin, in looking at exhibits 5 through 15 in total, the geology exhibits, if you will, do you believe that the request under consideration today is the best and right plan to protect correlative rights, prevent waste, and maximize resource recovery?
Yes, I do.
Okay. With that, I'm done with Mr. Griffin, subject to cross-examination.
Division?
Yes, Mr. Chairman. The division does have a couple questions. I'm going to turn that over to Mr. Dustin Doucette to ask those questions.
Proceed.
Yeah, Dustin Doucette for the division. If you'll turn to Exhibit 8, please. So my question on here, I think your testimony, Mr. Griffin, was that that outer ellipse was roughly the 20-acre drainage. Is that correct?
That's correct.
So my question has to do with those microseismic events. They're in that inner ellipse mainly. I guess the question kind of goes to, is there drainage outside of those microseismic events, i.e. drainage from the matrix, et cetera, outside of those events?
So that question, drainage area and how that relates to the microseismic events, we're diving into simulation theory. So I'll try to keep this brief, but when you're pumping proppant down a well and that horsepower is causing the rock to break, the proppant is in a medium that helps transport the sand grains, the proppant, out to the fracture. Now, we're not able to get proppant all the way out to the tips, so the farthest reaches of the microseismic. So I might have, the rock might have broken and made just like a little bit of noise, but as soon as we put the pressure back on, there's nothing to hold that fracture open. So at the tips, at that 20 acre, we expect that there's mostly going to get closure on the fractures and reduced to little to no recovery at the tip of the fracture. So if we look at how the proppant goes into the fracture and goes out to the farthest microseismic event, there's 3 separate radii that we would talk about. The outer one is the microseismic events. That's where the noise happens. The inner next circle would be how far we got proppant out. Well, we might have only got 2, 3, 4, 5 grains of proppant out there. And so that's, but because of the rock mechanics, when it settles down, you're probably going to squish and lose your conductivity again. The inner circle is where you have effective propped fractures, or nice open fractures. And so a lion's share, predominant, the greatest share of your production comes from the inner circle, which would be where the production stands. Is propped, the cracks are open, the oil's easy to flow, and then as you get farther and farther out, there's fewer grains of sand holding it open until you get to the far 20 acre extent, and there's essentially no sand to hold those fractures open. So in response to your question, I would say that there's little to no drainage outside of the 20 acre ellipse. That being said, there are occasional higher porosity, higher permeability stringers that may pop in once in a while, but those are reasonably rare. And we have a whole mixed bag of rock quality. So, you know, the effort is to capture those reserves close to the well and not trying to have the oil clear out a long ways away, because that'll be effectively captured in other wells. Does that answer the question?
Yeah, I think so. So effectively, you're saying there's no outside of the fracture network, you're getting limited entry from your permeability, your matrix perm into those fractures from movement of oil in this area.
Yeah, that's correct. So if the rock quality, I mean, if we were in the really good stuff right up on the beach, Waltz Valley Red Wash, we could drain larger areas, but because we're coming down into the lower shore face, it's harder to drain without putting fractures and proppant into place. And that proppant, even though there's an event where the rock cracked, we're not getting the wedge out there to hold that crack open at the far extremes of the ellipse.
So just kind of a follow-up to that. I don't know if you're aware of the kind of the lease line wells that were allowed in 27004, reducing this setback, and with kind of the testimony you provided on the drainage radii of these wells. Do you feel reducing that setback where we have these lease line wells will affect correlative rights in any manner?
If I'm not mistaken, most of those lease line wells are on an east-west relationship, and we're not requesting any sort of change on the east-west perspective. Michael, jump in if we need more detail there.
Can you guys hear me?
We can hear you, Michael.
Okay. Yeah, that order was put in place, and those lands do have common ownership. Generally, our area mainly being sections 35 all the way over to 33, and then sections 3 and 4. Those are going to be the same production interest owner. So that's why those that matter was put forth, was because of the same ownership on both sides.
Okay, thank you. I'm done.
Thank you, Dustin. Okay, and back to you, Division. Haley?
The division doesn't have any further questions. Thank you, Chairman Gill.
Okay. Let's turn to the board members. Any questions for this witness?
Chairman, this is Chris Hansen. I do have a few questions I'd like to ask.
Proceed.
Let's stick on Exhibit 8. I just need an explanation again of the upper left-hand corner exhibit, the colors of the dots and what they represent.
You bet. So that's a horizontal well. It was drilled by Crescent Point, and each stage of the frac is a different color of dots. So when you're completing the horizontal, I'll go clear out to the toe. I'll put in a set of perfs. I pump my frac. Those perfs create an ellipse around those spots. I set a plug. I come back up. I do another set of perfs. I pump a frac, and I have a new set of dots or microseismic events. And so you'll get some overlap in a horizontal well from stage to stage to stage. So I'm basically starting at the toe, perf and frac plug, perf and frac plug, perf and frac plug, all the way back up through the heel. So each color is one stage, one frac job, if you would. And by focusing only on the green dots, then we're saying like, well, what is the area? What's the azimuth? What's the aspect ratio of the green dots within that area? And it looks about a 3-to-1. 3-to-1 ratio is about what we use in our ellipse. There are some where the ellipse is going to be more squished, others where it's more radial, and that's a function of the difference between the stress, the maximum stress and the minimum stress, and a function of rock quality and a function of the rock mechanics, or how easily does that rock break. Visually, when you look at the green dots, you have to filter out all the other dots to think about one single stage and how that would look in a vertical wall.
Okay, thank you. Do you know what formation they were in and what type of rock they were horizontally drilling in?
I believe that was the Castle Peak in that well.
Give me a moment. I've got another question, but I've got to go down to the exhibit.
Which exhibit? And I can help show it on the screen.
Trying to do that deliberation channel after this.
I'm getting there. Sorry.
No, you're fine.
Shoot. Exhibit 13. Now, earlier there was a discussion about you being excited to see the sands in one of the particular wells, and I believe it was TR 27-33720. Is that correct?
That's correct.
Do you know what those sands represent in your strat column? What type of sand they were? Were they in the transgressive regressive environment you described? Which sands do you think those represent?
Those are Wasatch River channels. So that's part of the fluvial system where the river is dumping into the lake. So, okay. You know, as a beach might be hundreds of to maybe thousands of feet of continuity. A river is going to be, 200, 300, a big river, maybe, 600 feet across for a big river. And so these little channels are the point bars in the Wasatch fluvial system.
So what you're saying is the extent of these is maybe horizontally 600 feet in length, and how wide?
There's a lot of good studies that have gone into that. They're based on outcrops from Western Colorado, Rex Cole, Camella, they've done some really good studies. But in general, we're looking at a height to width ratio. So this same channel, which is 20 feet thick, 15 to 20 feet thick, is probably, based on their correlations, 300 feet wide.
I guess where I'm going with this is, if we know the aerial extent of these channel sands, is there any validity to the concern that Bayless raised that if you're draining one of these channel sands, you may be draining some of their some of the reservoir they've encountered? In other words, is there a possibility, do you think, that they would have encountered a similar, well, not similar, the same channel sand? Well, I guess that's not quite the correct answer. If in their well they have encountered a channel sand, do you anticipate that you would encounter the same channel sand drilling in that area, in your drilling unit? Would you think you would have any possibility of hitting that same permeable channel sand?
So let's look at the first 3 wells in this cross section. These wells are 660 feet apart. And the closest that will be to Bayless is, by my calculation, if we were super risk tolerant, moved right up to the hard line, the closest we could be to Bayless is 980 feet. And these wells are 660 feet apart, and we're not seeing well-to-well correlation on the Wasatch channels. So I think it's unlikely that we would drain them in the Wasatch. The other part of that question is the fluvial channels. You think about your river and your favorite fishing hole and how the river kind of moves this way and moves that way, and you're standing up on the cut bank and you look across the cut bank and there's a nice pack of sand, and then the river kind of goes straight and then it turns another corner and there's another package of sand. These point bars are notoriously disconnected. It's not like there's just one continuous deposit of sand from the top of the river all the way to the bottom of the river. The deposits tend to happen in the curves and the U-turns and the corners of the well. And then the little straightaways, you get lower quality rocks and less drainage. So when you're drilling in the Wasatch Formation, you're crossing your fingers and you're hoping that you will find these point bars. But it's a statistical play and almost impossible to map. And even if you have 2 channels and 2 separate wells, there's no guarantee that it's the same river, because maybe that river was here and we had a flood event and the river shifted over a half mile and you have a new river channel. Those, even if they're stratigraphically similar, the likelihood that they're connected from a pressure and oil in place model, it's more difficult to connect channels than it is connect beaches.
So what you're describing is a point bar system and a meandering stream of relatively small channel, not extensive wide channel sands that were developed in a significantly large river system, but a rather small river system where point bars were deposited in the meandering system. Their aerial extent is probably limited to a few hundred feet and a few feet thick. Is that sound right?
Yeah, generally. I mean, a good point bar will be 600 feet by, in this interval in the Green River Formation or the Wasatch Formation, by 15 feet thick. Then that's an amazing thickness. Generally, they're 10.5. So the size of the river that was dumping into Lake Uinta at this time, it's not a Mississippi River. It's more like a Green River, Duchesne River, smaller type tributaries that we're dumping into the Lake Uinta. That being said, if you go south on the southern edge where we're looking at Monument Butte, there were some really big rivers and deltas on that side of the lake that were just pouring these big continuous deltaic channel sands into that area. So it's a little bit different scenario on this side of the lake as opposed to the south side.
Okay, that helps me. Thank you. I'm done.
Thank you. Other board members, any questions? Rich Borden.
Hi, yes, this is Rich Borden. Two questions. The regional stress fields that you've been showing in a lot of figures, is that about north 60 west in this area that you've been highlighting? Or could you give me the azimuth?
The azimuth would be about 285. So we're about 15 degrees north of a due east-west azimuth. So we're 180 would be east-west, and then we just crank it up about 15 degrees to the northwest. And as you go farther west, we get into like Windy Ridge and the northern part of Monument Butte. And then there's a big corner where things just head up to the north. Yeah, and that's again, the Uinta Basin is under this stress regime where the whole thing has kind of been twisted. And that twist, the big wrench, creates these this unique stress orientation.
Okay, so north 75 west or so. The other question, the Wasatch River systems that were emptying into the lake, were they flowing kind of in an east to west direction, given your cross section thing? Or do you know the orientation of those? And the reason I think that's important is I assume these channel sands would be elongated in the direction of, you know, the orientation of the flow of the channel itself.
In general, the channel would be perpendicular to your shore face. So if the beach goes, let's say if the beach was due north-south, your river is probably going to be, you know, coming 90 degrees perpendicular into that. The lake being all angles of the compass, you know, depending where you are, you're going to have a different angle channel feeding into the lake. So in our area, if you look at the exhibit, can you zoom in just a little bit, Mitch, on the upper right hand? So you can see the shore face has been mapped in this area. The river is going to be roughly perpendicular to that shore face. So if I'm on the northeast, then my channel is going to be coming in from the northeast to the southwest. But there's a whole arc across that area. So if I'm right on the eastern tip of the lake, then I would say my channel is going to be heading due east up into the Douglas Creek Arch. That area.
Okay, thank you. I'm done.
Okay. Other board members, questions?
Yes, I have a question.
Church, please proceed.
Yes, Stephen Church, could you go to Exhibit 12, please?
No.
So we're talking about commingling here from the upper Wasatch all the way up through the middle Green River, which is quite an extensive section. I'm interested in your completion technique here versus horizontal wells where you're all in one zone at one pressure regime. If you enter here and start completing from the bottom to the top, do you anticipate doing this entire interval at one time as you do in horizontal wells, or do you anticipate limited entry fracs beginning at the base and then some production and then moving up as your production dwindles? Or what is the procedure you look at doing here?
Generally, we would do this in two phases, because not only is there a pressure difference, there's an oil quality difference. And as you get up into the mahogany bench, it's thicker, a little bit gooier. And if you try to commingle that entire section all in one completion, you can have some incremental difficulty in the treatment program, the chemicals that you would use to keep the oil moving. So we generally do from the Garden Gulch marker down through the upper part of the Wasatch. That would be your first go at completing the well. And then those, as you produce that oil in place, and when the oil drops below an economic threshold, then we would come up and in the same well, recomplete some portion of the upper well. Now, that being said, the exact sliver of where I draw that line might change on a well by well basis. So maybe on my initial completion, I'm halfway below the Garden Gulch and into the Douglas Creek, and then the recompletion would be up through the Mahogany Bench. But we don't have any examples where we have yet successfully commingled the entire section all in one go.
Okay, thank you very much. I'm finished.
And anyone else have questions? Mr. Brown, please proceed.
Mr. Griffin, you've presented some excellent information on porosity, permeability, well pressure, fluvial depositional environments. Of all of this information that you have presented, what is your most compelling argument for the board that you will not infringe on Bayless's reserves?
Well, the two questions, or two parts to that question is, one, the orientation of the stress and the size and shape of the ellipse. So the size and shape of the ellipse, again, are fracture azimuth and rock quality on a 20-acre drainage. And the other part of that question, I think, is the closest we can get, even with the existing setbacks, is 980 feet. The well center would actually be 1,000 feet. And so we are well within default spacing with the setback from the Bayless well.
And Mr. Brown, if I can jump in and maybe help, this is Mitch Mayo here. I'm going to refer Mr. Griffin back to one of the early exhibits, and maybe this will help. Mr. Griffin, it's true that the same interval we're talking about here, going down into the lower Wasatch, has been spaced in other orders in the nearby area. Is that correct?
That's correct. Our type log and commingled interval is almost an exact carbon copy of 270-02. And
do you mean 03?
Oh, yeah, 03. Yeah, 270-03. That's the same interval, the same rocks, the same.
So the board has previously approved the exact same interval and commingling for production in these lands and these lands that directly abut the lands at issue?
That is correct.
Okay. Does that help, Mr. Brown?
It does. Thank you both. Mr. Chair, I'm done.
Thank you very much. Any second thoughts, board members, or additional questions? I've got a couple, but before I go to mine, anybody else want to follow-up questions? Okay. Could we go to Exhibit 5? Let's see. Yeah, my question on this is that you've got the Bluebell Altamont field down dip. Is that a unique, I mean, it's a monster area. Is that a unique situation generally where most of the time the oil and gas is at the top of an anticline or something like that?
So the way we look at it is there's two different ways to trap gas, oil and gas. You have structural traps, which you have a big anticline, and that's generally in conventional high porosity, high permeability. Oil will migrate up dip until it finds a nice structural cap. In the Uinta Basin, we have stratigraphic traps. So it's whenever a beach pinches out or a channel pinches out or a limestone body pinches out, those upper edge lithologic boundaries become strat traps as well. And if we go whole hydrocarbon model and look at the Uinta Basin, the deepest part of the lake, when Lake Uinta was in place 50 million years ago in the Eocene, that's where all the organic material rained down over 10 million years and got stacked up, buried and compressed and cooked. So Altamont Bluebell is frequently referred to as the kitchen. And so that's where the oil is generated, and that all the stratigraphic column, heat and pressure is trying to squeeze that oil out to the edges. And it migrates up dip into these other fields. So that's the source, the reservoir, and the original depositional location of most of the oil in the Uinta Basin. And with enough time, it would all migrate out, and there'd be no oil left in the Central Basin. But we don't have that much, haven't been through that much time yet.
Go to Exhibit 7. You can see there's sort of that. It's like something had a car wreck, was going from right to left and then smacked into something, pushed upwards. Does modern science know what's causing that? Is it some explanation of why that is so abrupt at that point?
I love that question. It's as a geologist, Mitch is going to have to text me and cut me short on the end. If you go back all the way to the Precambrian, there was a failed rift valley, and this was all flat, and that failed rift valley got filled full of sand, which became the Uinta Mountains. So the Uinta Mountains are unique in that they run east-west. Very, very few mountain ranges in North America run east-west, but the Uinta Mountains is this big, dense, huge pile of quartzite. And over time, we're looking at Jurassic, and then we're into the late Cretaceous, and we start to have mountain building events, continental bumper cars. And so the North American continent gets in a little traffic jam, as you would say, and the Rocky Mountains start getting pushed up. So if I go back to dinosaur time, the Dinosaur National Monument, there were no Rocky Mountains in Colorado. It was flat and ocean and bottom of the ocean during the deposition of the Mancos. So as that got pushed up, I'm taking four states of area, and I'm just hammering it in this compressional event and pushing all that up. Well, the Uinta Mountains, they're this big, dense piece of rock right in the middle of that collision. So if you go to Wyoming, the old younger rocks got pushed on top of younger rocks. That would be the Wyoming overthrust. And here in the Uinta Basin, because the mountains were essentially in the way, it caused a different behavior of how the rocks sheared and piled up on each other during what they call the laramide orogeny. If you go down farther south into what they call the hinge line, where Wolverine has their field, that's their alignment, and their rocks, younger rocks and older rocks, is related again to that same mountain building event. So with everything getting smashed up in this continental bumper cars, it's like, to me, I think of it, we're pushing this whole front of rock ahead of us, but on the north, just off the north side of the map, the Uinta Mountains are in the way, and I can't push anymore. But to the south, I'm able to keep pushing, and it creates this rotational stress, this big wrench. And that wrench is, if I put a big pipe wrench, 4 miles across and just grabbed onto it, I would put that bend in the rock. Was that succinct enough, or did I go too long on that?
Well, that was perfect. That was perfect for me. And then the last question I have is on, pardon me, online. I think it was already asked. It was on Exhibit 12. Let me just look at that exhibit again. Yeah, I got that. Okay, I asked that and asked and answered, so we're fine. Okay, seeing no other hands up from the board, I'd like to suggest two or three things. First of all, I think we need a break. And the second thing is that at the end of this matter, we would like to go into executive session to discuss it for two reasons. One is to test the system, and the second one is to discuss this matter and come up with a conclusion. So board members, I'm asking you to put the, or to find the link that we will need to go into executive session and have that available. My question for Mr. Mayo and for the board members and for the division, would a half-hour break for just a bite, something to eat, be sufficient? Would you like a full hour? Or we'll just have a break of a few minutes, say 15 minutes? Well, you got A, B, and C, 15, 30, and a 60-minute break.
Okay.
Does anyone have?
Chairman, I'll go first. This is Mitch Mayo. I wanted to ask two follow-up questions to Mr. Griffin to just clarify some of the questions from the board. After that, Mr. Seifer has just two slides he's going to be discussing. So, we're as flexible as need be. I would imagine his testimony in total is 15 minutes with cross-examination. So however the board would like to proceed, if we pushed ahead, we could probably be done with this matter in 20 minutes. If we wait till after break, we can do 15, 30, or an hour. I have no objection.
Let's have a 15-minute break, and we'll come back. Board members, is any objection to that? Seeing none, we're on a break.
Okay, thank you.
live.
Oil, gas, and mining. We're back live on the Bainbridge matter. We're to you, Mr. Mayo, for your next witness.
Unmute Mitch.
Mitch, we can't hear you.
There we go. Is that better?
Yeah.
I thought it best to mute myself during the break so I didn't embarrass me. Chairman,
the Supreme Court did a virtual meeting, and you've heard the rest of the story.
I have. It's everybody's terrible nightmare they wake up from these days is this idea that you're in a work meeting and you're going to the bathroom or something. So I'm glad I didn't do that. But before I move on, Chairman Gill, thanks for that break. I would like to ask Mr. Griffin just a couple more questions to kind of help address the concerns raised or questions raised by the various board members, if that's okay.
Yeah, finish what you need to get done.
Okay, it'll just take a minute, I would imagine. Mr. Griffin, are you there?
I am.
Okay. A couple questions were raised. Mr. Hansen, I believe, asked a question about the channel sands that you identified. And the question, if I can paraphrase it, and hopefully he'll step in if I misparaphrase it, was you see these kind of stringers, these channel sands that are the more porous rock in the Wasatch Formation as you get down into it. Is it possible that you hit one of those channel sands and travels and basically interferes with or drains from the Aurora Federal well that Bayless references in its comment letter? He asked that question, and I guess the question I would ask of you is, if we assume that you drilled a well 330 feet away from that section line, almost 1,000 feet away from the Aurora Federal well, and you hit one of those channel sands that happened to be connected to the Bayless well, is it not true that, in essence, that would mean that the Aurora Federal well had been draining from Bainbridge lands since it came on production?
Yes, that would be a possible scenario. Highly likely that they're connected, but if it indeed is the same channel and they're draining us, yes.
Okay, so it's highly unlikely that you would be connected via one of those channels because of the aerial limitations in those channels. But even if you were, essentially it would be a protective offset well in that situation where they had been draining you and now this well would be draining them. So under either circumstance, it's appropriate to put a well at 330 feet, geologically speaking.
That's correct.
Okay. Mr. Hansen, if I messed up your question, please follow up.
Mr. Chairman, this is Chris Hansen. I'm glad that Mr. Mayo asked that question because I had that very same concern or question in my mind when I first read the Bayless letter. Is if they're claiming that there's a possibility of interference, they've already interfered. So I'm glad you asked that question.
Well, thank you. Yeah, and it should also be noted, as Mr. Anderson testified, Finley obviously received this as the operator of that well and expressed no public comment regarding the same objections that Bayless had.
Thank you. We appreciate that.
Thank you. With that, I'm done with Mr. Griffin, and I will move on to Mr. Seifer. Mr. Seifer, are you there?
Yes, sir, I am.
Okay. And can you see and hear him all right, Mr. Chairman?
Yes.
Okay. Mr. Seifer, will you please state your full name and business address for the record?
My name is Jeffrey Seifer. My business address is Bainbridge Uinta, LLC at 8150 North Central Expressway, Suite 650, Dallas, Texas, 75206.
Okay. And will you please tell the board your job title and your job responsibilities generally and as they relate to the lands here under discussion?
My job title is the Director of Reservoir Engineering, and I handle the field development plans and for Bainbridge for Three Rivers Field, sorry.
Okay. Okay. And so you are familiar with the lands that are subject to this request today?
Yes, sir, I am.
Okay. Before I get into the exhibits, I'd like to have you testify as an expert in reservoir engineering. And so I will undertake to qualify you as an expert with the division's allowance, if that's okay.
Yes.
Mr. Seifert, you have not testified before the Utah Board of Oil, Gas, and Mining in the past. Is that correct?
No, sir, I have not.
Okay. But have you testified in other states before their analogous oil and gas commissions?
Yes, I'm a professional engineer in the state of Texas and have appeared before the Railroad Commission numerous times, as well as the Louisiana boards as well on similar matters.
Okay. And will you please go through your background, similar to what Mr. Griffin did, your education, career, and kind of how it led you to this day?
Yes, I graduated from Texas A&M University and then became employed by ExxonMobil, where I worked my way up with Bainbridge.
Okay. So since Bainbridge acquired this asset from Ultra?
Yes, sir.
Okay. Do you feel as though you're fairly familiar in that capacity with the reservoir underlying the Three Rivers Field and the development plans that Bainbridge is proposing?
I am.
Okay. Subject to any voir dire from the division, if necessary, I'd like to have Mr. Seifert recognized as an expert in reservoir engineering.
Thank you. Division?
Thank you.
16 and Exhibit 17. Are you familiar with these exhibits? Do you recognize them?
Yes.
16 and Exhibit 17. Are you familiar with these exhibits? Do you recognize them?
Yes, sir, I do.
Board through this and tell them what this demonstrates related to the wells requested.
Yes, this is showing the economics for the well. The top curve is a type curve, the top graph right there. The red is the gas, the green is the oil, and the blue is the associated water. The oil starts off at approximately 150 barrels a day and reduces from there.
Okay.
And this is from the Green River Wasatch Formation. I used a NRI of 82, almost 82.5%.
Is that typical for Bainbridge's position?
Yes, sir. That's our average.
Okay.
And using a 94,600 barrel oil reserves, gas of 102 million, I get a payout of 1.5 years. And that's using SEC prices end of year 2019, which is standard practice for most public companies use the end of year. And that's when we started this process, was in January. So.
Okay. So you used $56 a barrel roughly. Obviously it's declined since then, volatilely a lot, let's say, but it's gone kind of up and down. Do you still believe that these wells are economic as proposed today?
Yes, sir. It'll extend the payout quite a bit, but they are economic.
So economic, but maybe not something that Bainbridge would choose to drill this week.
Correct. But we've got to be planning. We've got to get our development all together and get everything permitted and the whole process well in advance to be prepared for when those prices meet that level.
Sure. Okay. Thank you. If we may skip to the next exhibit, Exhibit 17. Same thing here, if you wouldn't mind. Walk the board through what this depicts and what it says for the recovery here on the lands that you expect.
Sure. This is a look at the total development in our areas inside of red. If we fully developed with the rest of the wells, you got a total area for our volumetrics of 3,497 acres. And you previously saw a porosity of average around 7%, water saturation of 30%, which leaves 70% oil saturation. We use a BSABO of 1.24 reservoir barrels per stock tank barrel to give us a total under these lands stock tank oil in place of 330,816,200 barrels. Cum to date production is 2,921,350 barrels. And if we drill all 143 wells with an EUR per well of 94,600, That'll give a total EUR of 13,527,800 barrels. This added together and divided by the area, the oil in place, you get a recovery factor of 5%, which is pretty standard of the vertical wells out here in the Uinta Basin.
Okay, so the cumulative production is around 3 million barrels, let's say, from the wells that have been drilled. They have life left on them still, and so they will continue to produce. But what you're expecting from the additional wells that are already spaced into these lands, assuming this deepening of the productive interval, is an additional 14 million barrels of oil will be recovered from these lands.
Yeah, all correct.
Okay, and so a total of approximately 17 million total production, or 5% of the oil in place, will be recovered if this request is granted.
Correct.
Okay, and Ms. Davis, I don't know if you're paying attention, but Ms. Davis asked a question, I believe, of Mr. Griffin about the number of wells that were being included. 143, am I correct that indicates the number of additional wells that can be drilled under the current 2 wells per 40 acre density?
Yes, that's 2 wells per 40.
Okay, so a well here, a well here, a well here, a well here. There's 143 locations within these spaced lands for additional wells.
Correct.
Okay. Sorry, Ms. Davis. Yeah.
That brings up the question, why particularly on the border? Why not in the interior of this drilling unit?
In terms
I'm not sure I follow exactly. Ms.
Okay,
Davis.
there's 140 locations available.
Mm-hmm.
So you are asking to drill with 100-foot setbacks. It appears that there are plenty of locations for drilling, not necessarily within 100 feet of the drilling unit. So the question is, why right next to the drilling unit boundary?
Well, let me answer that, because I think Mr. Seifer might not be the best witness to do that, and see if I can help answer it. Along this boundary that you can see, these red outlines, those demark where Bainbridge owns an interest on this side and does not own on this side. And so against these boundaries here, the 330 and 460 foot setbacks, 330 foot north-south, 460 foot east-west will apply. The only place where 100-foot setbacks from the section or lease line would apply is in a situation like 36 and 35 next to each other. If, let's say, for example, Sitla owns all of section 36 and all of section 35. That's not the case, but let's just say that's the case. And let's say Bainbridge owns the lease on all of those minerals, then essentially Bainbridge is permitted, and this is already the spacing that applies on these lands. So this is not something Bainbridge is requesting, but the spacing that applies to these lands currently allows for Bainbridge to put a well 100 feet from this line and 100 feet from this line if it chose to. The reason being that whether it comes out of this hole or this hole, Sitla and Bainbridge in that hypothetical example would be getting the exact same pay. So there really isn't any protection of correlative rights that's necessary. Does that answer the question?
Yes, I understand that. I thought we were talking about right along the northern boundary, not the boundaries between 35 and 36.
Yeah, between the northern boundary, the issue for the board to decide today is whether the setbacks that are in place are, let me go back to another exhibit that maybe will help. The boundaries that are in place now, currently along that northern boundary, the Bayless well, for example, that they commented on is somewhere right around the word request. The current setbacks on that boundary are this light green line. What Bainbridge is seeking is to, based on the geological testimony that you've seen today and the data submitted, not just in this cause, but in all the surrounding causes, is that this is clearly elliptical drainage meaning it goes like this at an angle. And so it doesn't make sense geologically to have a radial or a circular drainage pattern. It's not really how it's draining under the ground. And so what Bainbridge is seeking to do is recognize that geologic fact that there's going to be less drainage to the north and south than there is to the east and west. And in doing so is asking to move this setback 130 feet to the north up against that. So there still would be, under any circumstances, 330 feet setbacks from that northern boundary of the spaced area that we're looking at today.
Thank you for that clarification.
You're welcome.
Okay.
Mr. Seifer, I think we've kind of covered your testimony. In consideration of these two exhibits, 16 and 17, you also believe that this request under consideration today is the best plan to protect correlative rights, maximize resource recovery, and prevent waste?
I do.
Okay. With that, subject to cross-examination from the division or the board, I'm done examining Mr. Seifer.
Thank you. Division?
Thank you, Mr. Chair. The division does not have any questions of Mr. Seifer. Wait, just a minute. That's correct. The division has no questions.
Thank you. Board members, any questions of this witness? Seeing none, then we are to the division for its presentation.
Thank you, Mr. Chair. The division doesn't have any presentation to provide to the board. Based on the testimony that has been provided today and the documents and exhibits that have been provided to the board and to the division does not have any objections to the granting of this request for agency action.
Okay. Board members, any questions for the division? Okay, then we are back to Mr. Mayo for summation.
Okay, before I sum, is now an appropriate time to move for admission of my exhibits, Mr. Chairman?
Yeah.
Okay, I'd like to move to admit exhibits 1 through 20, including exhibit 2.1, and also the supplemental exhibit 21 that was filed yesterday.
Division?
The division has no objections.
Board members? Those exhibits are so admitted.
Okay. Mr. Chairman, members of the board, I'm going to keep my sum up brief. I'd like to point out that what Bainbridge is doing today is essentially continuing the spacing that exists on these lands with two slight modifications. One is adding in an extra 1,000 feet or the top 1,000 feet of the Wasatch Formation so that Bainbridge can hope to capitalize on some of those additional sands in the upper Wasatch that produce oil, and to reduce the north-south setbacks where ownership is different across a section or lease line from 460 feet to 330 feet. It is our position that the relief requested in this request for agency action is reasonable and is in keeping with standard practice in the basin, not to mention with various other causes that have been entered across this field and in adjacent areas to this field. With that, we ask that the board approve the request for agency action as pleaded and as clarified today via testimony, and maintain the current existing spacing orders except for those two slight modifications sought here today. And with that, I would rest.
Okay. Thank you very much. I think the whole board would tell you that was an excellent presentation, Mr. Mayo. I certainly enjoyed it personally.
Well, thank you.
Board members, if you don't need another break, what we would like to do is to go into executive session by having you trigger the link that you have previously been provided. And so we'll go off the record for this portion of the hearing, and we will go into executive session for deliberations. I have a question from Mr. Brown.
Mr. Chairman, this is for the technical group. Do we have to log out of this session before we log into the other one?
Yes, that's affirmative. We'd recommend that.
Thank you.
Is there a way to test it?
The microphone is live. If you want to,
What's it?
the microphone is live on YouTube again.
Okay, just give me the countdown.
Stand by 1 second.
No problem.
Mr. Richard Borden, how do you vote?
Yay.
Mr. Michael Brown, how do you vote?
Yay.
Mr. Stephen Church, how do you vote?
Yay.
Ms. Susan Davis, how do you vote?
Yay.
Mr. Rulon Gill, Chairman, how do you vote?
Hey,
Mr. Chris Hansen, Vice Chairman, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
let the record show that it is unanimous. Mr. Mayo, will you be kind enough to prepare the order and submit it to council?
I'm happy to do that. I'll try and get that submitted early part of next week, Mr. Chairman.
And I think on behalf of the whole board, would you submit to the Bainbridge management that this is one of the best presentations we've had for a while? We generally have superb to excellent to superb, but this was really a very nice presentation. Well done on a complex issue dealing with orientations of fractures and things like that. So we would appreciate if you'd pass that on to your top management.
I will indeed, and I appreciate that feedback. Thank you.
You bet. Okay, we're going to take a lunch break. Would 30 minutes be sufficient, or would you like an hour?
An hour,
Okay,
an hour.
okay, we'll take an hour break to let staff and the court reporter have some time. So we'll be on break for an hour. Thank you.
Two, one.
Good afternoon, ladies and gentlemen. This is Rulon Gill, Chair of the Board of Oil, Gas, and Mining. We are going to our agenda item number 5, docket number 2017-013-A, cause number RONG-2017-01-A, in the matter of formal rulemaking associated with the 2017 and 2018 legislative amendments concerning forced pooling. We'll take appearances of council or just, I think what we're going to do is move it to the division, and then I think there are some members of the public that would like to comment that have already been prearranged. So with that, I think division, how would you like to go forward with that? Is that you, Haley?
Yes, it is.
And Natasha, are you on the line?
I think it'll be me for the division as well. John Baza.
We hate to, Mr. Director, we hate to bypass you. Thank you. Okay, then, how would you like to start this presentation? John, do you want to take the first start of it, or how do you?
I think Haley's going to introduce the position for the division, and then I'll jump in.
Okay.
Thank you, Mr. Chair. Let's start with the forced pooling, since we can hopefully knock that off our list pretty quickly. So the comment period closed last Friday at 5 p.m. and no comments were received. So there are no comments for the board to consider at this time. That's good news. Under the Rulemaking Act, Utah Code 63G-3-303 sub 12, it states that after the close of the public comment period, a rule will become effective on a date specified by the agency that is no sooner than 7 calendar days after the close of the public comment period. So as stated before, the comment period closed on Friday, May 22nd at 5:00 p.m. The soonest the board could set an effective date should be no sooner than Monday, June 1, at which time the division can send the notice of effective date to the Office of Administrative Rules. So at this time, the division would like to recommend to the board that it direct the division to send a notice of effective date to the Office of Administrative Rules to make this forced pooling rule become effective on June 1st, 2020.
Okay, board members, do you understand that this package of rules will become effective June 1st? Okay, seeing no hands or comments, okay, back to you, Haley.
Is it appropriate for the board to rule on that at this time?
Okay. We'll take that as a motion. The motion before you is to set the effective date for the pooling rules package to be effective June 1st, 2020. Any discussion of that? First of all, a second to that motion.
Can I jump in really quick?
Sure.
Can I also request that the board direct the division to submit the notice of effective date to the Office of Administrative Rules on that date?
Yes. Board members, do you understand that motion has been amended as Haley just said? Okay, I got several thumbs up. Okay, is there a second to that motion as amended?
I would second that.
Okay. Okay, any discussion of that motion? The motion before you is to set the effective date for the rules June 1st, 2020, and then as Haley, I'm not going to repeat it, but the actual language about sending it to authorizing the division to send that to administrative rules. Would you want to restate that so it's everyone's clear exactly what you wanted on that part of it?
Sure. So the division is requesting that the board direct it to send a notice of effective date to the Office of Administrative Rules on June 1st, 2020.
Okay. All right. I think everyone looks like to me they understand it. We'll take a roll call vote at this time.
Mr. Richard Borden, how do you vote?
Yay.
Mr. Michael Brown, how do you vote?
Yay.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote? I'm sorry, Susan, could you repeat?
Yes.
Thank you. Mr. Ruland Gill, Chairman, how do you vote?
Yes.
Mr. Chris Hansen, Vice Chairman, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
Yes.
Thank you, Mr. Chairman. I have 7 affirmative votes.
Let the record show that was unanimous. Mr. Bosna, did we, or Director Bosna, did we bypass you at all on anything you wanted to say on this matter?
Not at all. I think that that covers the first part, and then I'll be weighing in on the next agenda item.
Thank you. So now let's go to agenda item number 6. And thank you for all those that were involved in this first package of rules. It's a great first step in the conclusion of this major part of the pilot project. Okay, we're on agenda item number 6, docket number 2017-013, cause number RONG 2017-01. I believe isn't that also, we called that B? Or is that's just what it is? Okay, and it has to do with the emerging matters, including operatorship designation. And so we will turn the time over to the division and you decide what order of presentation you'd like to make.
Thank you, Chairman Gill. So since last month's board hearing, the division has worked to clarify the language in the operatorship that appeared to cause confusion last month. So we believe that the latest draft that was provided to all the board members greatly improves the readability and understanding of the proposed rules. Because those red lines were provided to the board members, the division does not intend to go slide by slide through the rule language like we did last month, since the edits are stylistic in nature and only serve as clarification. However, the division found it helpful to create visual aids in describing each of the 6 scenarios wherein an owner can become a designated operator. Additionally, in working further with outside parties, there's one remaining issue that the division does not support but would like to bring to the board's attention for discussion at this time. And that is the issue of the 10-day waiting period and whether or not that 10-day period can be shortened. The division has prepared 2 additional slides that show the difference between the division's proposed language and the language proposed by the Utah Petroleum Association. So the division would like to present those slides following the division's visual aids on the 6 scenarios wherein the owner can become a designated operator. So Director Baza, I understand that you're prepared to walk through those 6 scenarios. Is that correct?
Yes, I am. And if you'll give me a moment, I will try to bring up the slide deck.
We have that on the screen now. Thank you.
Okay. So you can see it in full screen mode. I'm hoping. I can't see your faces, but I can see the slides that I'm presenting. And again, as Haley indicated, we tried to create some diagrams of what operatorship represents as characterized by the rule language. So I'll just jump into it. This is the first and the most simple case described by Rule R649-2-4 1.1. This is a situation where a drilling unit is already established, and you might look at that as either 2 sections of land or just an area where a well is being drilled. In this case, Company A has an undivided 55% of the working interest within the drilling unit area. That is obviously greater than 50% ownership or control. In this case, fairly straightforward. Company A is designated as the operator for the well and the drilling unit. This is case number 2, where a drilling unit is established. This is where there is ownership of 50% or less. In this case, Company B has an undivided 40% of the working interest within the drilling unit area. Company B has authorization from another company, Company C, which owns an additional 20% of the working interest in the drilling unit. And so that gives combined, because they have the authorization from Company C, it gives a combined control of 60%. In this case, Company B is designated as the operator for the well and the drilling unit. So that's the second case defined by the rule, and this is R649-2-4, Part 1.2. The third case is R649-2-4, Part 1.3. This is another case where a drilling unit is established. And this is an interesting one because it talks about a joint operating agreement that is already in place. In this case, it's because there has been a well drilled or an establishment of a board action, such as compulsory pooling. Company D has been designated as the operator of the drilling unit area, and a JOA is in place. However, Company D chooses to non-consent the proposed operation to drill a new well within the drilling unit. In this case, the consenting parties under the JOA determined that one of the owners, owner A, who is also party to the JOA, should be the designated operator of the new well, if the terms of the JOA so provide. Owner A would become the designated operator of that new well, while Company D retains the operatorship of other wells within the drilling unit. And this is kind of a unique situation, but according to the parties and stakeholders which we've discussed this with, it can happen. And so those are the 3 cases where a drilling unit has already been established. I'll now move to the situation where no drilling unit has been established. This is proposed Rule R649-2-4, Part 2.1. In this case, there's a well that is proposed through 2 separate leases and then an unleased tract in the middle. there is ownership of greater than 50% by either holding the lease or by owning ownership of interest within the unleased tract. Company A has leased 75% of the leases along the well path. That includes both lease A and lease B. If Company A also owns an undivided fee interest in the unleased portion of the well path, then Company A is designated operator of the well by ownership or control of more than 50%. This is case 2 described by the rule, R649-2-4, part 2.2. Again, no drilling unit is established, but this is where less than 50% is owned, but there's an authorization of an additional owner. In this case, Company B has obtained lease A directly and has authorization from Company C, lessee of lease B, to operate the well. If Company B or C also own an undivided fee interest in the unleased portion, then Company B is designated as operator of the well. So C has basically authorized Company B to control through ownership of lease A, lease B, plus undivided interest in the unleased tract. And this is the last case contemplated by the rule, R649-2-4, part 2.3. No drilling unit is established. And again, it has to do with the existence of a JOA. Company D has been designated as operator under the terms of a JOA, but chooses to non-consent the drilling of a new well. Parties to the JOA that was entered into by greater than 50% of the leased working interest and owning an undivided fee interest in the unleased portion of the well path determined that owner A, who is also a party to the JOA, should be the designated operator of the new well if the terms of the JOA so provide. Owner A becomes designated operator of the new well, while Company D remains the operator of other wells in the contract area covered by the JOA. So having gone through those 6 cases, I'll pause because I'm sure there are questions, and I may need some help in order to truly describe what these diagrams are depicting.
Okay, John, I'm going to ask the board members if they have any questions at this time. I see none. Going once? Okay, then we're back to you, John.
All right, so hopefully those diagrams were helpful. These slides were sent to the board both yesterday and this morning. We had to modify one of them and make a slight editing change, but hopefully you've got the electronic copy of the slide deck. But Haley, I will let you introduce the next part of the slides if you want to.
Sure, I can do that. So, like I discussed in the beginning, there's disagreement between stakeholders and the division on whether the 10-day waiting period that is triggered with the approval of an APD can be shortened. So the next 2 slides contain language that there's 2 provisions, one in 649-2-4 and a second provision in 649-3-4, where a shortening of the 10-day period is contemplated. So in this number 3, you'll see this language in blue is currently the language that has been approved by the division and has been approved by the stakeholders. However, the language that's in orange, you'll see discusses or contemplates a 10-day, a shortening of the 10-day period. And that language has been proposed by the Utah Petroleum Association, and they have counsel on today to answer any questions that board members may have. But as far as the division is concerned, where the blue language ends, the division would propose to put a period after that, but the division believed it was important to call attention to this so that we can have further discussions and make a determination on this issue today so that we can hopefully move these operatorship rules forward.
Would you like me to show the second slide too?
Yes, please.
I think this is referenced in the last slide, but this is in the APD rule.
So again, in this slide, it discusses a shortening of the 10-day period, but this slide, the language in this goes a little farther than the last slide in that it narrows the situations in which the 10-day period can be shortened. So this is contemplating that shortening would only occur in situations where the operator has a lease that's expiring and the circumstances were outside the operator's control such that they couldn't have filed the APD sooner, whatever reasons may exist, but that lease is expiring, and if they don't take specific action to act on that lease, then they will lose that lease. So it's my understanding that this language, coupled with the language in the previous slide, Utah Petroleum Association believes that just this one narrow situation should be allowed for shortening of that 10-day period. I just wanted to state one more time that the division believes, similar to this section as the previous section, that the division would prefer that a period be placed at the end of the blue language and not include the orange language. But again, we wanted to bring this to the board's attention so that they can consider this recommendation by the Utah Petroleum Association.
Okay, board members, are you clear that the blue language is accepted by the stakeholders and the division? The yellow or orange language is submitted by the Utah Petroleum Association as additional language. Okay, and how would you like us to proceed? Are you through and would like us to let's stop right there. Any procedural questions or questions about what is before you? Susan Davis, please.
I have a question for Director Baza. How long is a typical lease or contract for a drilling unit?
I'm going to go from memory, but it seems like the primary term of many leases is 10 years. It could be that some leases are being issued for shorter periods than that, such as 5 years now. But I think the primary term of a lease is generally that, 5 or 10 years. There could be situations where for other reasons and other circumstances, an operator acquires that lease towards the end of its primary term and is then under a very tight deadline to exercise those rights. But I think the primary term of most leases is generally several years.
Thank you, I'm done.
Okay, any other questions of Mr. Baza at this time? Okay. We're back to Haley. Susan, please.
Yes, there's just one additional thing that I would like to discuss, and that is why the division does not support the 10-day, a shortening of the 10-day period. This is an example that Director Baza has come up with and has shared, I think, before, but I think it's on point, and I would like to share it again with the board just to reiterate the division's position. And that is after an APD is approved, if there is a 10-day waiting period, then suppose that I have ownership interests out in the basin and I'm trying to monitor to make sure, anything going on out there is not infringing upon my rights or anything. So if there's a 10-day period that's firm, then I can put on my calendar, my work calendar, every Wednesday at 10 a.m. for it to pop up a reminder so that I can go onto the Division of Oil, Gas, and Mining's website, and I can look at the APDs that have been approved, and I can see if any of those affect me or affect my rights. If the 10-day period is allowed to be shortened, then that pretty much requires me to go onto the division's website every single day and check to see what APDs have been approved and check to see if any of those have any effect on me or my interests. So the division believes that requiring, people with interests, especially when they may not be as sophisticated or may not keep as good of an eye on it, the requirement that they go on every single day is onerous and it's overly burdensome. And that necessarily results if the possibility of the 10-day period is shortened, because then the period might be 2 days or it might be 4 days, and I won't know unless I'm on there checking every single day. So with a firm 10-day period, everybody knows that they can go on once a week and check, and it provides assurances to all parties that, there's this period, it's firm, it's a specific length of time, and it allows the operators who want to go out and take action that they know that, the 10 days is 10 days and they don't have to worry about challenges coming up after the fact. So I just wanted to reiterate that situation. I know you guys have heard it before, but I just wanted to put in one more plug for it and give the board some context for the division's position on why the division prefers this blue language, but I'll defer back to the board on whether you guys have any questions.
Okay, board members, any questions of Haley at this time? Seeing none, then just to be clear, we have a couple of stakeholders that are available to answer questions, and so I'm going to start that process with Mr. Hunter. Can you hear me? I'm not getting you, Tony. Try that again.
Mute button and the electronic one, belt and suspenders.
All right.
If everyone can hear me now,
I have a question for you.
Shoot, go ahead.
And that is, talk to us about that Utah Petroleum Association language, and then any other thoughts that you may have.
Certainly. To start, the original proposal had the 10 days. We had contacted the division. A 30-day period might be more appropriate. That proposal was accepted, endorsed by the division at the February hearing, and then when the new language came out, that proposal was retracted. I still believe, and my clients still believe, that the 30-day period is more appropriate, and I want to just sort of piggyback on what Haley just said a moment ago. The idea of calendaring a weekly check of the division's website is a perfectly reasonable one. But the problem is that after you find out that there is an approved APD that may affect your rights, you then are going to have to file a request. That is not a quick or easy thing in all cases. First of all, there has to be an attorney that doesn't have conflicts. Secondly, an attorney that has availability at the time to actually file the RAA. And thirdly, there should be some time for investigating the facts and figuring out if there's something that's actionable or just, I don't want that to happen. And especially with a 10-day period, there will certainly be a shoot first, ask questions later attitude among anyone that thinks that there might be something wrong with an approved APD, rather than taking a few days to iron out the details, perhaps contact the operator, whatever. But with that short trigger period, it's going to almost certainly cause people to say, if I don't do something now, I'm going to lose my chance later. Because just a reminder, what that 10-day, it doesn't tell an operator you can't drill. It just says you better be right. And the application for permit to drill is supposed to be supported by an affidavit by the company's own personnel or staff, by their outside attorney verifying title. So they should be, I believe, willing to put their money where their mouth is and bear that risk that they could be wrong. And it doesn't mean they have to stop everything. And I think that's an issue that needs to be brought up as well. The regulation that what happens if the protest happens, if the RAA is filed, is that preparation for drilling has to stop. If there's actual drilling operations going on, do they keep going? So that might be another maybe point of clarification that we should address as well. If the well has been spud and it's already in, when a protest comes in, does that request for agency action saying, wait a minute, that APD was improvidently granted, does that stop drilling operations as well as preparation for drilling? Which leads me to my final point on this. The preparation for drilling can be anything from moving a rig on site to just starting a road. And so that starting of a road could happen months in advance. And that may be a done deal even by the time the APD is submitted, because all that takes is a valid surface use, a valid surface use agreement. You just need to have permission from the landowner to dump gravel. It doesn't take an APD to get that out there. So preparation for drilling may in fact be complete by the time that the APD is even filed, let alone approved. So the structure of the rule, the structure of the protest period is there to protect people who are not on the ground physically and can watch what's going on, who might be out of state, who might not be sophisticated, as Haley said. There are a variety of reasons why a firm protest period is important. So to give people notice, to give people opportunity to be heard, and to let people figure out exactly how they're going to respond to the environment that we're creating here. That firm protest period needs to be 30 days. Because even if you're checking every week, that's theoretically possible that if you just missed the posting date, you might only have 4 days to find counsel and file an RAA. And I think all the practitioners in the room will tell you that's an awfully short trigger to do anything, let alone something complicated and technical having to do with title and oil and gas operations. And thank you, I'm done.
Thank you, Tony. Board members, any questions for Tony? Okay, it appears that you've understood what he said. Let me take Julianne. The comment period has closed. Did you receive any comments on this rulemaking?
No, I have not.
Okay.
I think that comments on rulemaking might have come to Natasha.
Natasha, can you respond to that, please?
Yeah, I haven't received any comments. I think most of the discussion has been between different councils.
Okay. My proposed process from here on out would be to go to Mr. Mayo and then to Mr. McDonald, where I'm going to ask each of you a question that hopefully will elicit an informed basis for the board to make a decision. So, Mr. Mayo, my question for you has to do with the Utah Petroleum Association language and any other thoughts that you may have on this proposed package of dealing with operatorship.
Thanks, Chairman Gill. I'm happy to go. I noticed Fred waving his hand, so I'll keep this brief. Here's what I will say is I think Mr. Hunter's right. There's obvious benefits in having hard deadlines. I think what the UPA has proposed makes a lot of sense in the practical, messy world that we actually live in, where things happen and mistakes need to be corrected, things need to be dealt with on an immediate basis. And so I do think, the law provides this in virtually all cases where there's an emergency exception. There's a hard and fast rule, but you can get around it if. And I think that's exactly what this rule as drafted by the division and as supplemented by UPA's language does. I want to make one point about Mr. Hunter's comments. I agree generally with them that, it is a small oil and gas legal community. It is difficult to find counsel sometimes who isn't conflicted. That being said, I think it's important for the board to be reminded over and over again that the parties who will be objecting to something like this own a large percentage of a drilling unit. And those parties typically have counsel they work with already. Those parties typically are able to keep track of their interests a little easier. And so this isn't in a force pooling matter. There would be a small farmer who had never been before the Board of Oil, Gas, and Mining, and those would be the concerns that we were primarily addressing. In this, what we're really dealing with is someone who thinks they may be the better operator of a unit. And those are the people whose interests we need to make sure this rule protects. I think the division's draft, complete with the orange language from the UPA, does just that. And I'm done, Chairman.
Thank you. Board members, any questions for Mr. Mayo? Okay, I've got a question for Mr. McDonald. Noting that the comment period has closed, you have made yourself available to answer questions. My question to you is, what's your position on that yellow language? And could you tell us why you're supporting that? And then any other comments? My question is, do you have any other comments, and what are they related to this rulemaking?
Thank you, Mr. Chairman. Fred McDonald on behalf of the UPA and Ovintiv Production, Inc. The language here was drafted because many members expressed the concern that there had been circumstances beyond their control that would have required a shortened time period. Example would be typically if you were trying to drill, for example, on an Indian lease, and the BIA had delays and delays and delays, which didn't toll the term of a lease, and therefore it would be a situation where you have a fee lease in a drilling unit that would be held up to drill because the BIA hadn't approved an APD, and then of course the division has to approve it. The situation here, if you recall, the initial draft that UPA had simply stated for good cause. And talking to the members, we tried to take that issue and the potential complications for the division to one specific circumstance, and that is if a lease or contract is going to expire before the APD time period has left. I want to point out to the board that the current regulations, and I'm going to cite R 649 3-4 sub 9, is a situation where it says that the division can approve an APD if there's a pending request for agency action for these exact same reasons. In other words, by regulation already in place, the board recognizes that this is a unique circumstance. As far as, again, the rule provides that it has to be good cause shown, and it's within the division's discretion. If there's concerns about operators delaying, waiting, due to their own circumstances, the division has a discretion to deny that shortening of the time period. It has to be good cause. And we've limited it to one specific circumstance here, trying to address the concerns of both that were expressed somewhat by Mr. Hunter, also by the board last month, by limiting it to this one specific circumstance. So this is why we're advocating for this addition to cover this one particular circumstance. Now, addressing the issue of the 30 days versus 10 days, I want to remind the board that North Dakota has a 3-day period. So there's only 3 days, and people have to monitor that as well. So the point was, with 10 days, you provide sufficient time, and it was a fair, reasonable thing. I also want to reiterate what Mr. Mayo stated, that the parties who are concerned with this should be sophisticated people. If they're going to protest an APD or protest operatorship, they better be in a position to be able to drill a well or operate. And so the concerns about the little guy really are not, it's a concern that's not valid under these circumstances. I do want to state that UPA very much appreciates the division working with us and the collaboration that went on with the stakeholders through this process. I think the rest of the rules have worked out fine. It's only this one last part that is really at issue for UPA and its members. With that, I'm concluding my comments.
Board members, these 3 experts have made themselves available for questions. Remind you that the comment period is closed, but they do have questions. So I'll start with you, Ms. Davis.
This question is for Fred McDonald. John Baza just testified that leases are 5 years or 10 years. Why would we be within 10 days before drilling commences? That seems like a lack of planning to me.
Well, again, Ms. Davis, the situation would be that the primary terms are very, very much. Actually, the more common situation now would be 5 years, but I've seen some as many as 90 days. I've seen some with 1 year. But again, the more typical situation is a new operator, for example, XCL purchasing Axia's interest, and they may have some leaseholds that have had that period of time, but now they have a short period of time in which to drill. And again, I want to also caveat that this 10-day rule will probably very rarely be requested. But again, if the operator, it's intended to cover the situation beyond the operator's reasonable control. If the division sees that the operator simply delayed and didn't get things going, it has the discretion to deny that and keep the 10 days in place. So that would be my explanation to your question. And I'm done with my comment.
Can I help? Go ahead.
I think I still have the floor. Mr. Hunter, and I was in those early meetings, said that the original was 30 days. 10 days is a big compromise from that. How about a compromise of we go 30 days with good cause to shorten it to 10 days as a compromise? That's a question to you, both Mr. McDonald and Mr. Mayo.
I'll go first. The 10 days is to allow the period to get going with it. If somebody's going to protest, they should be able to do it within the 10-day period. As I said, North Dakota, it's only 3 days. And UPA's version has always been 10 days. It hasn't been the 30 days that was originally. It was 10 days. The division came back with 30 days, and we said, no, this is the reason why with the 10 days. It's sufficient practice. It should be adequate. There's adequate notice out there. The parties that would be protesting should already know ahead in advance if they're going to be protesting. And we feel that the 10 days is more than adequate time. End of my comment.
Doesn't you still have the mic?
Mr. Mayo?
Yeah, I mean, I have to agree. I think in some cases it compromise feels like the right solution, and in lots of situations it is. I think in a situation like this, the right solution is just the right solution, and we have to think about what the goals are we're really trying to achieve by the number we're putting out there. And the goals we're trying to achieve by this, whether it's 3 days or 10 days or 30 days, is effectively to start a clock and say, after this period in time, this party, who, as Mr. McDonald pointed out, is going to have a majority interest in the drilling unit, is allowed to go ahead and begin their drilling risk-free. You have a finite amount of time, person who has a different opinion, to get in and make your case heard. One point to note about the 10 days and the lack of ability to find someone As you may remember from this morning's hearing, I made an appearance on behalf of Highland Mist Mine. I was contacted on, I believe it was Wednesday or Thursday of last week, and possibly even Friday, by Mr. Yoder for the first time. And I was able to clear conflicts, represent him, work with division to settle that matter. And that's in something with a client I've never heard of and had no experience with. And so Mr. Hunter is correct. There is a functional limit. I think the reality going to 30 days does nothing to, does very little, I won't say nothing, to expand the number of people whose interests can be protected, but it does a significant amount to delay drilling by those who are actually engaged in oil and gas production in the basin. And I think for that reason, 10 days is a really fair and reasonable compromise, if you will, between the 3 and 30 days. And with that, I'm done.
Mr. Hunter, do you have any more comments?
Thank you, Ms. Davis. Yeah, I just want to respond to a couple of things that Mitch and Fred both said. The reference to North Dakota is kind of instructive. One difference between North Dakota and Utah is that almost in every case, the land is spaced prior to people trying to do an APD. These rules specifically contemplate, and Mr. Baza's slides illustrated some situations in which that might not be the case. An operator will be designated and an APD will be approved prior to lands being spaced. And maybe it won't ever be spaced at all. That is an issue because at least with a spacing order in place, people will have received notice that they're going to be sharing in a just and reasonable proportion of lands and a productive resource in a certain geographical area, which then you can use to go to the website to monitor, hey, there's someone in my area. That's not necessarily going to be the case under these rules. Both Mr. McDonald and Mr. Mayo both said, well, typically, the typical company and the people that are really going to be working with these rules are thus and such and have these characteristics. That may be true, but these rules need to apply to everyone, everywhere and always. And you're not going to catch everyone everywhere and always if the rules are set up so that we don't know if the time frame is going to be solid or not. It might be shortened. We don't. People are not going to always have the time necessary to respond to it. Mr. Mayo's example of his own experience is kind of illustrative of that as well. His client was able to secure representation. It still took 4 days between the Friday when he got notified and the Wednesday to now. That's the time frame that I illustrated. I posited, and I don't know if Mr. Mayo would agree with this, but 4 days is untypical. But he was able to do it. It's not impossible. It's just untypical. So just keeping all that in mind, the spacing issue is a big problem here. And I didn't go into it because I wasn't asked the question. And if we're going to have some more time to chat about it, that's fine. But the North Dakota difference here is that spacing is done. And everyone has had time to go through and find out the ownership. It's not necessarily done all the time, but the practice is it's already finished. And the notice period is, in my view, you don't get notice. If it's posted on the website, that's not a notice, not an administrative agency type situation where you're going to be having adjudicative matter to determine whether or not you have the right to do something which, absent a board order or a division rule, you would have the right to do. I'm done. Thank you.
I'm done as well, Mr. Chairman.
Okay, thank you. Board members, any other questions of these three people that are online? I'm going to go to Haley, and then I'm going to go to Gordon Moon. And anyone else, raise your hand as soon as you'd like to talk. So Haley, go ahead.
Thank you, Chairman Gill. I just wanted to follow up on one comment that Mr. Mayo had made, and that was that the shortening of the 10-day period is a method for dealing with emergency situations, and that without that, the rules don't contemplate the division being able to address situations in an emergency. And so I just wanted to briefly point the division to the current rule. It is Utah Admin Code 649-2-1, sub 3. And that provision states, quote, exceptions to the general rules may also be granted by the director or authorized agent for good cause shown and shall prevail as against the general rules. So the division considered that this provision was in existence and believed that there may be situations, rare situations, where there really is an emergency that the division feels like it needs to accommodate. And the division believes that this current provision that is in existence can deal with this situation and that we don't need to write it into this new rule. And that's all I had to say. Thank you.
Thank you. Mr. Moon?
So just following up on Ms. Sosa's comments there, so perhaps there could just be a reference to that rule rather than having it in this rule, because I can see situations where that might be necessary, but very rarely. And then Susan, you know, a compromise between 10 and 30 would be 20. How would you feel about a 20-day time period?
I would be fine with a 20-day time period. I share the concern about exceptions, but since there is already an exception in the rule, I think we could go 20. Frankly, I think less than 10 is unreasonable for any reason. I'm done.
Okay. Seeing no other hands, I'm going to go into you, Mr. McDonald. And, let me go to Chris Hansen first, if I could, because you may be able to include his answer, and then I have some things I'd like to say. But I would like, I think let me do this, if I can make a recommendation. I want to hear from Chris Hansen, then we're going to take a 10-minute break, let everyone kind of get your thoughts, and then I'd like to make some statements about my experience and maybe perhaps give a little guidance from my point of view. So, Mr. Hansen, what's your question or comment?
Thank you. I wanted to hear Mr. McDonald's response to what Mr. Hunter was discussing about the 3-day limit. I noticed he had a response. I think he wanted to make to that. So maybe I jumped the gun when I raised my hand. You were going to go to Mr. McDonald.
Okay, Mr. McDonald. If everyone's okay with that, I don't see other hands. Mr. McDonald, will you reply to Mr. Hansen?
Thank you, Mr. Chairman. Yes, Mr. Hansen, as Mr. Hunter said, it's not always that it's spaced up in North Dakota. They have a rule that you have to, after an APD, then you go in and space. So in that case, it would be an APD approval, and then you come in and space based on the information you get. So when he says that not always, it kind of goes back to what he was arguing against us. The point being is that 3 days was deemed sufficient to provide notice to those people who need to and make their protests known at that time. I also wanted to address what Ms. Sousa said. Yes, that general rule is there, but the concerns that were expressed is what constitutes good cause when you go to those rules, and that leaves it wide open. And there was concern expressed when we paralleled that language in the rule that we sent that was discussed last month. We tried to tighten that down with the good cause being under this one circumstance if a lease or contract was to expire, which makes it clear that is the only way that you can do it, and going forward with that. So while we have that general rule that they can always ask for an exception on good cause shown, it doesn't alleviate the problem of what is good cause. By leaving this language in, you've set it as to one specific circumstance that the division can grant under those circumstances. That concludes my comment.
Okay, we're going to take a 10-minute break, and we'll come back in 10 minutes. So thank you.
4, 3, 2, 1. Meeting is back.
Sure. One thing, and this is directed to Julianne and Natasha. The question I have for the record is, has anyone else requested to participate in this matter that you received? Julianne, would you answer that first?
No, Mr. Chairman, no others have asked to participate.
Okay. Natasha, would you answer that from your perspective?
I have not heard anything about participating.
Okay. So I just want to make sure that record showed that we have the parties involved that asked to participate and we weren't excluding anyone else. Okay, I think there's some assumptions that I'd like to address. And I hope I can do that. And the perspective I want to give you is dealing with what our requirement is as a board. And this comes from section 40-6-1 of the Utah Code that provides that as a board, we are encouraged to promote the oil and gas drilling. And as such, that's kind of one of the standards by which we have to measure what we do. I'm going to direct my comments to the assumption of who the players are in this arena. Yes, there is the relationship between the landowner and the lessee oil and gas company, contractor, or something like that. Let's call that number one. And yes, there are leases that have provisions in them that have special expiration provisions in addition to the normal standard term of 5 years. I think if Mr. Moon was to comment, there are leases out there right now in the Uinta Basin that are 2 years. But those are with landowners, private landowners. You could have federal leases that have blackout periods where even though you wanted to drill, there's a no drilling provision in it. That could be where you have strutting sage grouse or something like that, or elk migrations or any other provision like that. But that's one class of situations. The second class is companies to companies. Certain companies have a much better database of information than their competitor companies, but they don't have the lease. And so they can go to the company that has the insufficient data and say, we want to drill on your land. And we'll go ahead and do that under what they call a farm out agreement. I must have seen 1,000 of those in my career where the well is drilled in the last days of the lease term between the companies. It's not a lessee-lessor problem. It's between two companies working out the deal. And there can be any number of deals, and they could have had ongoing negotiations for years that eventually end up being in the drilling of a well. The third one is the party that wants to drill and a third party. So you have the lessee, you got a third party. It may be availability of rigs. You've got a contract for a rig. You've got a contract for a supplier. You may have a contract with a fracking company. You could have banking arrangements. You could be in the middle of a merger or acquisition. You could have just done a merger and acquisition and be surprised by the fact that you have a lease out there that's going to expire, and you've got someone that's going to drill it, wants to drill it. My point is, and the bottom line of this statement is that you cannot predict all possible situations that can occur at the end of the life of the lease. But if what those circumstances are result in the drilling of a well, then that's what we're supposed to be doing, is encouraging that very fact. So let's take some of the arguments. The toughest issues we're ever going to have are when all sides are correct. And you have to choose between them. We do have a statement from the division that it's administratively, it is tough for everyone to do things on a daily basis. Others, it's administratively difficult to find an attorney in a short period of time. But that's not the requirement in statute for us. If as I believe that we will get more wells drilled under what I see as the Utah Petroleum Association position, that has to be the tiebreaker. If I were king for a day, I probably would go to a shorter period of time than 10 days because the companies, this company relationship, which is going to be the predominant factual situation, they're designed to operate 48 hours, working days, weekends, whatever. And so they can handle, and they're built, their staffs and everything else are built to handle 48-hour decisions, particularly when a rig's on location. So from my perspective, if I feel that more wells will be drilled, then with that 10-day and able to get APDs, then that for me is a critical thing. But I didn't want you to go forward with your vote thinking that the only fact situation is lessor lessee. That's just not the case. And I'm done. Anyone else want to talk for a minute? And Fred, I think we were going back to you, were we not, when we break? So Fred, we're to you.
Thank you, Mr. Chairman. I just have one clarification. I made the reference to the existing regulation that the existing regulations already recognize this circumstance of lease expiration or contract expiration. The current regulation appears at 649 3-4 subparagraph 9. That same rule is in the new rules, but it's been redesignated as subsection 11. And I just want to make that clear for the board and the record.
Okay,
that completes it.
And board members, Mike Begley also caught that and wanted to make sure that the record showed that it was subsection. Haley, you're up. You own the mic.
Thank you. This is an issue that, can you guys hear me okay? Let me put this other one in. The division, during the break, the division staff brought up something to me that I thought would be useful to share with the board and that I think alleviates some of Mr. Hunter's concerns, and that is on the division's website. It doesn't only show new APDs that have been approved, but in a lot of situations where the applicant hasn't requested that the information be confidential, that information shows up on the division's website for a period of time prior to APD approval. So that is something that people can also used to help identify whether their interests are being affected prior to APD approval and not just post APD approval. And so I just wanted to bring that to the board's attention as well.
Thank you very much. Are you done?
Yes, I am done. Thank you.
Okay. So, board members, do you feel like you're starting to get a grasp of what it is? I actually do have one more question. I see Ricky, Enrico Browning, are you on as part of the UPA group?
Yes, Chairman Gill, I'm on.
Tell us the background of how 10 days was come up. Was that a compromise or was that?
Yes, German girl. I'm on.
Sure, I'm happy to do so. Through UPA, we had several discussions with our members over the course of these negotiations. We discussed, as Fred had alluded to, the North Dakota example where we have a number of operators that are also present and active in their 3-day rule, and had a very thorough conversation around the pros and cons of that 3-day rule. The general consensus, as Fred had stated, was that 30 days has always been too long in terms of tying up capital for the operators and in terms of exposing a lease risk. Chairman Gill, as you illustrated, there are a number of cases where it can be very challenging to have visibility. Perhaps you are taking over a lease, for example, which is something that we would anticipate could be a real situation coming ahead more often as we work through this economic downturn. And the general consensus from the membership was that 10 days was already a compromise position from the 3 days practiced in North Dakota that seems to work fairly well, particularly as we are using the website for notice. Most of those persons that would be active through this process are accustomed to going to the website. You have instantaneous access, whether you are setting a calendar reminder, as Ms. Sousa had noted, for once every Wednesday or for once every 3 days, whatever that period is. There are effective tools that allow you as a responsible operator or owner or lessor to maintain active knowledge of the situation that you are addressing. We had talked previously that UPA had a majority position, but not a consensus position on the forced polling rule. As I've stated previously to this board on the record, with operatorship, our positions have been consistently in consensus, not just a majority. There has been a strong level of agreement between the UPA membership on nearly every point that has been thoroughly discussed in this role. And thank you for the opportunity to engage. I know that it's a little bit challenging online, but I appreciate the opportunity.
Thank you very much. So, board members, last chance for final questions and comments. We're going to take a 2-minute break here. The council wants to talk to me for a minute. We're going to take just a 2-minute break, if that would be okay.
All right, thanks, Chris. Bye.
Okay, we are back.
We're back on the record. This is Chairman Gill from the Utah Board of Oil, Gas and Mining. Chris Hansen, I see your hand.
Yeah, thank you, Chairman Gill. I appreciate the conversations and the discussions that we've had, and maybe I'm the bad guy in this, and I'm willing to accept that position. But can we as a board vote on accepting the UPA language and get an idea of where the board stands on accepting the UPA language versus the divisions language? Can we do that?
Yes, if you want to make a motion.
Well, I'd like to make that motion just to see where we are. I'd like to get this thing to a conclusion. And I don't know if there are other discussions that people want to present that would change our opinion. I think we've heard it all. I'd just like to have a motion, make a motion that we vote up or down on the UPA language and the division language.
Okay, so if I understand you correctly, Mr. Hansen, the motion is to take a vote on the UPA language as an addition or without it?
Oh, I'm sorry. Yes, as an addition to the, yes, as an addition.
Okay, so the vote, the motion before you, and I need a second, as I understand it, is to approve the UPA language as being an addition in the two places that have been referenced to this draft rulemaking. Is there a second to that motion?
I'll second that.
Okay. Thank you. It's been seconded. Is there any discussion of that motion? Yes, Mr. Moon.
Could you just clarify to me what those two adjustments are?
Ask them to bring the slides up.
What's that?
The division to bring those two slides up.
Okay, let's, the part of the discussion, I'm going to ask the division, Mr. Director Baza, could you bring up those two provisions?
I certainly can.
So what he's going to be bringing up are for the record, are two slides that show the exact language that is part of this motion. The first one is in R 649-2-4 Part 3. And the second one is the R 649-3-4 Part 4. Okay, is there any question about what exactly you would be voting on? Okay, then I'm going to call the vote. Julianne, will you call roll call vote, please?
Mr. Richard Borden, how do you vote?
Yes, for accepting the proposed UPA language.
Mr. Michael R. Brown, how do you vote? Let me make sure there's, that last vote gave me a concern. If you vote yes, you're voting for the UPA language. If you vote no, you're voting against adding the UPA language. So let's go back and start that roll call vote again so we're clear on that.
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yay.
Ms. Susan Davis, how do you vote?
Nay, no.
No. Mr. Rulon Gill,
No.
how do you vote?
Yes.
Mr. Chris Hansen, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
No, I still have questions.
Mr. Chairman, I have 5 affirmative votes and 2 negative votes.
Okay, so I'll rule that passes 5-2 in terms of adding that language. Okay, Mr. Borden, you have the mic.
Yes, just a logistical complication. I have another commitment and I will have to leave in about 10 minutes.
Okay, thank you very much for that. The motion has carried. There may be more questions about it. It has the same effect as moving the issue. The only remaining thing for us to do today is that to vote whether we would like to move these rules to formal rulemaking as amended by the vote we just took. Is there a motion out there to move these rules to formal rulemaking?
Yes, I make a motion that we move these rules to formal rulemaking.
Is there a second to that motion?
I will second that.
Okay. Motion has been made and seconded. Is there a discussion that anyone would like to have about this? Seeing none, the motion before you is to move this package of rules dealing with operatorship as has been provided to you as amended with the UPA language to formal rulemaking. Julianne, will you call roll call vote?
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
No.
Mr. Rulon Gill, how do you vote?
Yes.
Mr. Chris Hansen, how do you vote?
Yes.
Mr. Gordon Moon, how do you vote?
We can't hear you, Mr. Moon. Turn on your mic, please.
I'm sorry. Yeah, given the fact that there's going to be more opportunity to discuss and for my questions, I vote yes.
Thank you. Mr. Chairman, I have 6 affirmative votes and 1 negative vote.
Thank you. I'm going to rule that motion passes and that the division be directed to take the necessary actions to move this issue forward to Director Steed and then on to the necessary parties. Finally, I would, before we entertain a motion to adjourn, I would like to have the floor for just a few minutes. This is a monumental day. We worked for 6 years for legislation, for understanding, for oil and gas companies to come in and drill, and it's been one of the greatest experiences of my life. I've actually been able to see the very best of all of you, particularly I think Director Baza. I think your attitude toward family, leadership style, your pursuit of excellence is just extraordinary. Board members, we haven't always agreed, but when we haven't agreed, the end product was that much better. It's been a great experience for me. Having said all that, this is my last board meeting. I need to keep a promise that I made, and so I will not be joining you any further. Mr. Hansen is the vice chair, and he will be stepping up to that until you have a chance to meet your new board member and to move forward. What happened? I made a promise to the Governor Herbert that if he was willing to give me an unprecedented fourth term, that I would go through May of this year. My prediction was that we would be done in March. With the pandemic and other issues coming up, that did not happen. But we're very close. I just, I can't tell, Mr. Hunter, Mr. Mayo, Mr. McDonald, Ricky, all of you, how much I've enjoyed pushing the limits of ideas and going months and months and months at a time with issues of first impressions. The whole state of Utah is better for what you've done. I look back on my 13 years now on the board as being some of the richest days of my life. I'm a better person for it. I've learned a lot. And I think the state, no matter where this thing goes, I think you can step back and tell your children and your grandchildren, your employers, those associated with you, that this was part of the greatest agency actions, the greatest hearings, the greatest movement. If this railroad gets built out of the Uinta Basin, you will have been involved in transforming a rural part of this state to perhaps a productive industrial part of this state. To all of you, I want to just give you my heartfelt appreciation for the times that like I said, I've seen the very best of all of you. Unfortunately, you've seen some of the worst of me. So it all works out, but it's been a great experience, and I wish you well. But more than anything else, please stay healthy. This is a troubling time. And with that, motion to adjourn is in order.
I don't think we can
So
make
moved.
I'm sorry. Rulon, Chairman Gill, I don't think we should make a motion until at least I have the opportunity to tell you thank you. I appreciate having served on the board with you for these past 12 plus years, and wish you well going forward. Keep in touch.
I'll be in touch whether you like it or not. Mr. Baza.
Mr. Gill, I can't begin to say how much we owe you for your great service over these many years. You've had a lot of input on the board, and it is an unfortunate circumstance that we're trying to deal with the pandemic during the time that your service ends, because we do want to celebrate the work that you've done for us. So please know that once we get back to normal, whatever the new normal is, that the division would like to find a time with the Board of Oil, Gas, and Mining to celebrate your many years of service to the state. And I want to wish you well in whatever endeavor you choose to do at this point.
Thank you very much. No, I don't need that, John, but your offer is very, very welcome. To have a chance to give back, to serve the state, it was never in it for the power. It was to try and make a difference. I hope I've been able to do a little bit of that. And so thank you all. Anyone want to make the motion? Seeing none.
I'll make the motion, Chairman Gill, but I want to say thank you.
So thank you, Mike.
And I will second it and second the thank you as well.
Well, Rich, this is going to be a game changer for Utah. And Rich, Mike Brown and Chris Hansen are 2 years into a project to help the state deal with some long-term major mining issues. that will be coming forth here in the near future, and I'll invite them to tell you the major progress that they've made on a long-term issue that is decades in the making and decades in this next solution. So thank you very much to all of you. And the motion before you is to adjourn. It's non-debatable.
Before we do, I was disconnected for a moment. I just wanted to say thank you, Chairman Gill, for your many years of service.
Thank you, Susan. You have provided a check and a balance and in a quality way that has been extraordinary. And I personally want to thank you for being willing to take that position because the process is much better for it. So thank you. With that, all in favor, raise your hand. Okay, no roll call votes needed. We're now adjourned. Thank you all. Thank you, Mike Begley.